So here you go. This is Emily C., my new bestie.
I hate the idea that someone out there hates me. I even hate thinking that Al-Qaeda hates me. I think if they got to know me, they wouldn't hate me.
This stole the show. Emily C. was phenomenal.
There's something you need to know.
What?
You're doing great.
Look at my baby. Here she is. Emily. 10 out of 10. Huge fan.
I see Emily C says 123. I trust her. She's really good.
Listen, Turtle, you gotta watch your language. I'm already live. So you need to follow the FCC guidelines.
He destroyed, left nothing in her path. It was so good.
Hello, everybody. Welcome back to part 3 of Drop 1 of the Sidebars. I'm Emily C. You might know me as Nicole Albert or Brian Albert or Laura McLaughlin, the stars of the show today. But today I'm just me, or today I'm Adam Lally and Judge Beverly Cannoni. And I am so excited for these sidebars because, to be perfectly honest, after the last ones, I was kind of spent from being Lally, and I was like, okay, well, that was enough. If anybody wants to read the rest of them, they can do that on their own. And I'm so glad that Queen Corri Hopkins talked me into doing these last ones, because I went through the sidebars that we're going to do today, and I pulled a bunch of video clips for them. And these are, in my opinion, the best ones from this first drop. We get a lot of new information, or just information about the federal grand jury and about cell phones and all sorts of stuff. So I'm very excited to welcome back Corri Hopkins, aka AJ and Yannetti and Little. How you doing?
Doing great. Glad to be here. Glad to close the loop, feel complete getting these sidebars done.
Like, truly, I'm so glad that you convinced me to do these today, because I really was like, okay, that was enough Adam Lally. I did pull a bunch of little commercial breaks that we can do today so that we can get a little vacation from being these exhausting people. But I'm very excited about this. And I've forgotten to do this the last 2 times, but today I'm going to, because I added new sea creatures. The sea creatures now are closed. No more requests. No more, what about this? What about that? Corri, how are you feeling today?
Yeah, let me see. Well, I love the seahorse. I feel good. What's like a happy one? There's a happy one, right?
Yeah, there's peaceful. There's the stingray is happy. The jellyfish is peaceful.
Yeah, those two.
Great.
What about you?
I feel the excited starfish up here at the top. I feel kind of like the little proud penguin that we made this happen, that you like pulled this together. You got us these sidebars. We acted them out. Like, I'm pretty proud of us. I feel good.
Okay, good. Yes, for the record, you have done like all of the work. Aside from like me getting the sidebars, you've done literally everything else. I just show up, grab some ties from like the closet and move on.
Yeah, as if getting the sidebars was super simple. They just made that really easy. You were like, hey, can I have these public documents I'm supposed to have? And they were like, sure, no problem. Here you go.
Exactly like that.
And before I forget, let me pull this down. Before I forget, I need to plug the trial channel, because for anybody that wants to revisit these, but like gets a headache from hearing Bev be such a pushy person, let's call her. Trial channel has been working so hard to pull the actual footage and match it with the closest like AI voice that that she could to be able to reenact these sidebars in a way that feels like how they actually went down in the courtroom. And it's so cool. They just premiered today. So after we're finished, if anybody wants to revisit in like a calmer way, those are out there now. And she's unbelievably amazing for being able to pull that all together. So just so cool. To start today before our acting, I did want to correct the record on one thing that I gave Bev a hard time for, but then once I looked at it a little bit more, I was like, fine, I was being a little bit hard on her. And I will admit this only because we're going to be extra hard on Bev today because she's not the nicest in these ones. But we talked about the time that she reprimanded Alan Jackson for calling the court reporter Nancy. And to be fair, he did it in whatever you call it, like testimony, like he did it in open court. So he was asking the question, like, what does the person seem to be doing? CPR, blah, blah. And then he said, I just want to make sure Nancy can get down what we're both saying. And that's when Bev the next day said, you referred to the court reporter as Nancy. We're more formal than that. I think it's more like not even about being more formal, but like people don't know who Nancy is. So sorry, Bev, that I gave you a hard time. I actually agree with you. He probably should have said Madam Court Reporter.
I'm with you 100%. I've never said a court reporter's name in my life, nor would I ever. I stick with Madam Court Reporter or perhaps a Mr. Court Reporter if that opportunity ever arises. I don't know that it has yet for me. But either way, yes. I don't know if it's done differently in California, if you say the names all the time, but that's I'm unfamiliar with that move as well. I will agree with her on that one for all the reasons that you said. We're about to, we have feelings about it.
So just to prove that we're not just out to get her, and we can admit when she was right. But let's get right into it because I really am so excited about these ones. So to give you the lay of the land, we're starting on May 3rd, 2024, when the jurors are about to leave for their field trip to head over to 34 Fairview and see the scene and see the car for the first time. This is not the viewing where the rock was, which makes it even more ridiculous that there was an Albert family rock on the yard a full 2 years after they had even moved out of the house. But we're just going to watch a tiny clip to set the scene of Alan Jackson in the, I have to switch this. Oh, I forgot I have to do that. Hold on. Remove that. Okay, we're going to hear Alan Jackson, just a tiny little clip in the courtroom.
What Mr. Lally just said, there's nothing magical about this other than it gives you perspective. It's an opportunity to introduce you in three-dimensional form to stuff that you've been seeing in two-dimensional form. Photographs, some of the testimony, diagrams that you might see.
I'm sorry, we're really pointed on what you can say.
What we're going to ask you to do is take special note of the relationships of physical items out at the scene. Much as Mr. Lally just indicated, there are going to be physical things out at the scene. What about a flagpole, a fire hydrant, a house? We're going to ask you to take special note of where those are in relation to other things physically at the scene. That will hopefully... Yeah.
How do I make this louder? I think he was just quiet. I think that one is just quiet because he's not close to the microphone. I think the rest of them, because Bev just sounded really loud in my ear. Let me just see. There was just one part I wanted to get to. So they're about to leave. This is we'll just see. They're about to leave. And then, hold on. And then suddenly they're like, actually, wait a second. Now I messed it all up. I had the timing right and everything. Hold on, people. I blame
needed a
Bev for this. I
little-
don't know why.
I think that's fair. We get a little OnlyFans action. We get, you know, passive aggression towards court officers.
Okay, so now they're like literally walking out of the room, and then they're like, actually,
Your Honor, I'm so sorry for the false start. I wanted to make one final record on the court's ruling. I respect the court's ruling on the.
Go ahead. You can make your record.
Maybe it would be better if I did it over here. I wanted to interpose an objection to.
So I think it would be better if you did it over here.
It's illegal. It's just illegal.
I don't know what you're doing. Come over here and tell me what you're going to do, and then I'll be back.
oh, that's a good idea. I can put the captions. Hold on. But that just cracked me up because Jackson's like, I'm going to do it over here. And she's like, no, do it over here. Okay. Hopefully, if I put the captions on for one, it stays on for all of them, but we'll see. Anyways, let's get to
I find
us now.
it so painful when the court, without the attorney saying it first, when the court says you can make your record because it is code for I am definitely not going to do whatever you want me to do, but sure, say it for appeal. What, knock yourself out, don't care.
Exactly. And that's what we're about to see. Okay. So Jackson says, I'll do it over here. And she's like, you'll do it over here. So now they go over there. And also she had just told the jury that they'll be out in 1 minute. Like there is a bus waiting. I see the ants in her pants. I don't know. Maybe I'm having like Stockholm syndrome from being Bev or something. I don't know why I'm apologizing for her so much right now. But anyways, so Bev says, I don't know what you're doing. Come over here and tell me what you want to do. And then I'll let you go back there and do it because you had ample opportunity to do it. So what are you doing?
I didn't have ample opportunity.
I just don't know if you're showing photos or you're describing the photos.
No, I'm going to cite a case. That's what I'm going to do.
Okay.
I'm just going to cite a case.
Okay, that's fine. So then they cite a case. They spend a lot, we're going to see, there's a lot of time on this day still spent frustrated about Caitlin Albert and Katie McLaughlin's relationship. So that's what he's doing here. And let me see if I can turn the
I
captions.
would make that record and ask the court to reconsider whether or not those 4 exhibits could be introduced. I don't need to make any big deal about it. I don't want to call her back to the stand, but I think the jurors, now having had the description of those photographs, should be able to see them in evidence. And I would
Okay.
submit.
All right. So that request is denied. The record's clear. So Ms. Reed is not going on this view. She just needs to make sure she's back here by the time we return. So Mr. Yannetti, you're nodding.
Yes,
You will
understood.
contact her and make sure
Understood.
she's back here.
Understood. All right, to the court, please.
And now we're off to the view. Okay, so now we're at the scene and they have a chance again, each one of the lawyers to kind of direct the jury to what they want them to see. So this is Mr. Lally, like winds howling and they're outside. And he says, good morning again, ladies and gentlemen. Again, as I stated in the courtroom, this is my opportunity to address you here. So some of the things that we talked about in there is what I would direct your attention to now. So you find yourself standing in a roadway. I would ask you to take note sort of that roadway, of its length, both as you came in and as you exit at the close of all of this. But also, I would like you to take note of just the condition of that roadway, the width of that roadway, what, if anything, you observe as far as lanes within that roadway, both in the middle and sort of towards the side of the roadway. I would ask that you take note in different areas as far as where that roadway ends and where sort of other properties or residences begin, where you find that to be, and specifically as it pertains to a residence to your right. I would ask you to take note of distances from areas as far as where we're standing now to where the roadway is, where we're standing now to where the house is, any doors or entrances, exits that you observe from that house, as well as anything else you note as far as a landmark for some sort of tangible objects that you observe within specifically the front area of the home, and specifically the front to the left as you're facing the home, in that area in front of the lawn, yard area of the home.
Hi, ladies and gentlemen. Again, I would echo a lot of what Mr. Lally just said. Like, no, you would not, Jackson. You would echo none of that. We just want you to get comfortable with the area surrounding the house, the roadway, the width of the roadway. I also want to remind you to pay special attention, if you wouldn't mind, and note an area to the right of the flagpole. Its relationship to the fence, the gate, its relationship to the front door that appears in the middle of the house, and another door that appears just to the left. I would also ask that you pay special attention, if you can, to the area of the driveway and what ingress and egress, entrance and exits would look like at the front of the house, as well as obstructions between those areas and the area adjacent to the flagpole here. I would also ask you to take some note of the roadway and whether or not it's perfectly straight, whether or not you see a curvature in the road, the width of roadway, both from curb to curb, as well as the width of the roadway from center line to the curb, things of that nature. The last thing I'd ask you to pay attention to is simply the length of the area from the mailbox all the way up to an area, it would be close to the natural property line, maybe here or beyond, the length as it pertains to vehicular traffic that may be parked. And that's about it. I think with that, that would satisfy us. Thank you, Your Honor. Oh, Your Honor, there's one more thing. There are a series of windows, both on the bottom floor and on the top floor. I would ask that you pay special attention to the window on the top left of the home and its relationship to where you're standing, as well as the property area in front as well. Thank you, Your Honor. Thank you.
So now that was to the jury, and now they have these special sidebars that when they go on field trips that are called outside the hearing of the jurors. So this is an outside of the hearing of the jurors, which is AKA a field trip sidebar. Your Honor, with the court's permission, what I would ask is just to give them a few minutes to do that, then take them over to the vehicle. Mr. Jackson pointed out that he would like to see inside the vehicle. It's just been a while since I've opened the door and see inside. Yes.
Yes, ma'am.
Just to look prior to the jury going over there. So with the court's permission, that's what we would, sure. Where you asked them to look at the driveway, why don't we go beyond the car first to the driveway and then walk back to the car?
Yannetti, they can't see the mailbox.
So, well, if we can tell them that, we'll walk past the car to the driveway and then come back to the car. Okay, we can do that. So now Lally tells them that they're going to look at the car. I cut that out because it took like 4 pages just for him to say, like, we're going to go look at the car. And Bev says to the court reporter, "Did you get that?" And the court reporter says, "No." It's apparently Laura McLaughlin is mumbling to herself. So then Bev says, "All right, hold on, please. So Miss McLaughlin, you have to say that again. This needs to be recorded." Inside the vehicle, counsel noted that there is a search warrant and business card of one of the troopers. We're going inside the vehicle to remove the search warrant and any law enforcement identification cards. They should be marked for ID. So the Commonwealth will take possession of this now. Did you bring stickers? So now this just goes back and forth. And then Yannetti says, like, can we take it back? That's okay. I just thought this part was funny because Court Officer Rose, whoever that is finally so excited. Trash? Timmy will take it. Court Officer Rose, that's my job. Okay. So do you want to close these doors and then open them for them? Explain to them, Mr. Jackson, it's your request we look in the car.
He's like, stop blaming me for stuff I didn't do. Mr. Jackson, it's Mr. Lally's request, but I have no objection.
All right. So why don't you just tell them what we're going to do? And then for the third time, Lally tells the jurors about looking in the car, and it takes another like 4 pages. And I cut those out for you. Now, I hope Runkle is okay with me playing this for you guys. It's just a really quick clip, but he also read the sidebars and he had the funniest commentary about Lally telling them all of this. So that's what we're going to watch a second of.
All right. So the view. Mr. Lally says, good morning again, ladies and gentlemen. Again, as I stated in the courtroom, this is my opportunity to address you here. So some of the things that we talked about in there is what I would direct your attention to now. So you find yourself standing in a roadway. I would ask you to take note, sort of that roadway, of its length, both as you came in and as you exit at the close of all of this. But also I'd ask you to take note of the condition of that roadway, the width of that roadway. What, if anything, you observe as far as lanes within that roadway, both in the middle and sort of towards the side of the roadway. By the way, this is also how Lally does dirty talk. If anybody has the misfortune of sleeping with Lally, he's like, I would ask you to take note of the length, of the width. What, if anything?
So I just had to include that. Are you kidding me?
I'm so glad you did. I love Runkle's laugh at his own jokes. Really gets me.
That laugh, he laughed for 20 seconds straight. It was just laughing. Okay, so now they're talking about looking in the car still. It's taking a long time.
All right, Jackson. Very briefly, and also to dovetail into what Mr. Lally just suggested, the height, the width of the vehicle is obviously important, and I would ask you to take note of the rear end of the vehicle, the bumper area, and the height specifically of the taillight area on the vehicle, as well as when you're taking a look at the rest of the car. That's it.
Now they're having their little vacation sidebar. How long are we going to stay? I mean, I'm fine, but I don't want to interrupt them, or I don't want to interrupt them either.
Yannetti, seems like at least a couple are still considering things.
I would say probably 5-10 minutes or so at the most. That should cover it. I think as long as we stand here, they are going to stay here. That's the other thing. But if you want, signal me when we should wrap it up and I'll start walking.
About 10 minutes.
The chief court officer said you guys, I have an inside scoop. Okay. The chief court officer said one particular juror wanted to know how far up the driveway she could go.
Yannetti, I'm in touch with the homeowner. They gave us permission to go on the property. I can call and ask if a juror could go on the property if nobody objects.
I wish we had known that before.
Well, I didn't expect that we'd go on the property.
I think we said nobody could go on the property when we started all this. I think it's safer to just go with that. Open it up on one end and then somebody else wants to do something else and then they want to go in the house. That's why I asked you all to work together on the view.
We did.
Okay. And then, you guys, this is my inside scoop. Okay, so there's a redacted part that we don't hear where one of the jurors says something. And the inside scoop is, I talked to Victoria George last night, and this is Victoria George she walked up to Judge Cannoni and said, are we supposed to read into where the car is placed, or was it just put there randomly? So now Bev is back with the lawyer saying, there is no question or answer. What does counsel suggest?
Jackson, our suggestion would be to tell the jurors that they are going to determine, you are going to determine based on the testimony where the car was or wasn't. It's here more for exhibit than specificity of, Yannetti, it's placed randomly right now, correct? I think that would be the answer. Jackson, they will just have to wait on who testifies to where they saw it.
I prefer not to comment at all on the evidence. We are here to stop and look. Those were my instructions. You're merely here to look.
I have no problem with that, as long as they don't think it's specifically placed, because it's not. Yannetti, that was the question.
I don't want to field questions because if there's one, there could be 15. And that's not the purpose of the view. What is the Commonwealth's position? I also said that this was the day that they took Victoria George's juror ball out of the picker. Laura McLaughlin says, I would suggest, oh, she's such a brown noser here. I would just suggest what you propose, perhaps with a limiting instruction as to they are the fact finders and they assess the weight and credibility through the evidence that will come out in trial.
Yannetti, I don't think there's any evidence to be evaluated with credibility, but it's really the opposite. I just love that Yannetti is like, okay, we're like looking at blades of grass. There's no credibility of the witnesses here to be assessing. It's just, we're here to look at the house. We aren't assessing credibility. That's kind of the point, because no one can testify here in front of you and we can't even talk to you about it. We're just looking.
And like they did place the car exactly where they said that she hit John. So like it was a valid question, and maybe they should have put it like across the street, like not exactly in the spot where they said that it happened. Anyways, what I'm inclined to say is that the purpose of a view is for you folks to stop and look and observe what you are seeing. And you can use this as evidence in your deliberations, just sort of what I said before. I think I'm inclined to also say no one can answer questions. Do you want the question part or no?
I think I would like you to say we are not allowed to answer questions.
I think that's good. Okay. Court officer, we will bring them together behind the car, Your Honor. Like behind the car where we're saying an accident happened. Okay. Counsel, please come, huddle up. Do you think we should wrap it up?
Jackson, sure. Yannetti, maybe ask them if there's any objection if we leave.
I've never done that before. When we decide when it's time, jurors don't object. I'm not inclined to do that. I will give them another few minutes. I think you are very fortunate that they are paying such close attention.
Yes.
Actually, counsel, it occurs to me that one of the jurors is pacing and measuring out pacing. It should have occurred to me earlier. They are also told that they are not to investigate, and that's pretty much investigation. So we're going to wrap it up. And now they took the bus back to the court, and the field trip is over. And now Lieutenant Gregory Woodbury is on the stand, who I had forgotten existed until this.
To us. And the information that Firefighter McLaughlin, without reference to what it was, but the information that Firefighter McLaughlin was able to obtain, did she communicate that to you and the other firefighters?
Yes. Yeah, she came in the ambulance, told us what she had heard.
As far as the information that Firefighter McLaughlin provided, did that comport with what you were observing as far as injuries to Mr. O'Keefe?
Objection.
Sustained. You can lay a foundation if.
Now, as far as, again, the injuries that you observed to Mr. O'Keefe in the back of the ambulance were what?
It was the bruising of the right eye and the scratches on the forearm.
And what, if anything, did Firefighter McLaughlin indicate to you had been told to her?
That someone said she had hit him, and he was last seen.
Objection.
Move to strike.
Sustained. That.
Now this sidebar. So it's hearsay, but not for the truth of the matter asserted, Your Honor. But
It's
the
not
state
hearsay.
of but the state of the mind of this witness as far as his treatment and diagnosis, as far as receiving information not in conformity with what he's observing on the patient and then seeking more information. So you have to lay a foundation for that. Actually, this is the one time I see Lally like fight for something because he needs this of Katie McLaughlin like actually having told somebody that Karen said I hit him at the scene. I think I did that. I think I did that as far as what his observations were. Not sufficient. If I don't have the statement, I can't ask him if it comports with what he's observed. What do you say, Mr. Yannetti?
Well, first of all, I have a question on the relevance of his state of mind as it pertains to the issues in this trial. And, I think it's just a backdoor way to get in some type of hearsay corroboration of Miss McLaughlin's testimony.
Corroboration? The jury has already heard from Miss McLaughlin as to what the statements were. We've also already heard those statements as related by 2 other witnesses separately. So what is it exactly? It's a good time for a lunch break. What is it exactly that you want to ask him? I want to ask him what he was told as far as firefighter McLaughlin learned from this person. And why do you say it's not hearsay? Again, the follow-up question that I'd like to ask about is whether or not that explained to him what the injuries were that he observed were purportedly what he was observing. For what purpose, though? Again, I think it goes to his treatment in relation to Mr. O'Keefe and how that was handled. What do you say, Mr. Yannetti?
Well, I say that, we haven't received any notice that this witness would be offered as an expert witness. I think there has been a lack of foundation in terms of his qualification to give an opinion of the status of the injuries and whether they comport with what he's viewing. He's not an expert pathologist, or he hasn't been qualified in any way. So I would object on that basis as well.
Because reminder, this is a lieutenant. Isn't this what you all put in through another paramedic, that I did tell Mr. Jackson he needed to lay a foundation? All right, we will take a lunch recess. When we come back, you can argue it to me. So now we're back from lunch. It's cross-examination by Yannetti about when so this is Lieutenant Woodbury is the one who comes back to the scene after he leaves for the Section 12 for Karen. So he's not there in this capacity for John. John is already gone. He's at the hospital, and he's there to section Karen.
Yannetti, my next and final line of cross-examination will be with regard to the injuries to his arm that this witness testified about. And the reason I'm approaching Sidebar is I would like to show him the autopsy photo that the court has previously seen, which depicts the injuries that he's described. Given the sensitive nature of it, I want to display that in open court without getting the court's permission first.
What does the Commonwealth say? As far as the photograph, I would anticipate something along, speak up. I'm sorry, I would anticipate something along the same lines that I would be seeking to introduce at a later time. Is this what he saw, though, in that short time in the ambulance? That I don't know.
Well, he saw those injuries, whether they had blood on them or not.
These are obviously going to come into evidence.
They are.
I'm just not sure this is the right witness.
Well, I want to explore that, Judge. And if I fail to lay a foundation, I will mark them for identification. But I want to show it to him and see if he will identify it.
Why do you need 3?
I don't.
Okay, I'm going to mark 1 for identification now. If he adopts it, you can put it in through him.
Great.
And if he doesn't adopt it, you can't.
I understand.
Mr. Jackson, please come back.
Oh, what's the letter for identification?
That will be N for ID. Thank you. Do you intend to put it up on the screen afterwards?
I would, yes.
All right, so get him to adopt it.
Yes.
And now Yannetti displays the photo that they were just talking about.
I would like to say, just for the record, that Yannetti has done everything right here. He was right that it's on direct, it was hearsay, and that there is no relevance to the state of mind, which is a hearsay exception. There's no relevance to the state of mind as that officer with respect to Katie McLaughlin's hearsay testimony as well, or hearsay statements. And he was right about when Lally tried to twist it into sort of an expert opinion. He's right that this guy can't testify as an expert. There's no foundation laid for that. And he was absolutely right and totally proper and professional to approach the court at sidebar before he put something somewhat controversial on the screen. He has done everything correct, and he is getting, like, you know, in the court's doing what the court's doing.
And he's doing it so politely too. Like, she's like, you need to get him to adopt it. Yes, I will. And if you don't, you can't use it. Yeah, I get that. I already said, yeah, what? So now this is the picture that they had just had a sidebar about, like, that they were looking at. They marked it for identification. It was in their faces. And now Bev says, I'm sorry, please take this down for a minute. I need to see counsel at sidebar. Jurors, feel free to stand up and stretch. What I hadn't noticed quite as clearly is the body shows up tremendously on the screen, and we've got a photographer over there aiming his camera at it.
I see.
You've got your IT guy. Can you block that out?
Jackson. Yes, we'll do that right now. Can we have 30 seconds?
Yeah. So can we take the photo?
It's electronic.
I understand that, but just so you know exactly where, just the arm.
Yannetti, just show that to him. Just show him what needs to be cropped off.
Jurors, feel free to stretch if you want. I thought they were already stretching. Then they go back for 1 second, and then she says, jurors, take a recess. So when you get cropped, if we could also print a copy of that and exchange it for...
Definitely, yeah.
What's been produced.
We wanted to print it.
Okay.
We wanted to print it so that you could see it before we put it up there.
That's great. And then we will swap the exhibits. Yes, that makes sense. Yes. Your Honor, while we're here, I'm sorry. He's like, nobody's paying attention to me. Just with reference to what the court had said once before, as far as Exhibit 160, so Miss Gilman was able to print out a redacted copy, okay, of both run reports for Mr. O'Keefe and for Miss Reed. Oh, is Miss Reed's going into evidence now? With the next witness, probably? So I just wanted to give counsel an opportunity to look at them, and court, obviously, before I did that. He's like, Yannetti was being a little bit too good there, so I want to do the same thing he was just doing. So now they talk about those exhibits for a little bit. Then they go back and forth with the clerk about numbering it. This went on for like pages and pages. And then finally they figure out the numbers. This just cracked me up. Do you see that? So Yannetti at the top says it's 382.
Okay. Yes, it's 382.
It's 382. That's what I said, didn't I?
No, you said 362.
So it was like literally 4 pages. And then she was like, okay, so 362. And then they were like, Bev, we just said it was 382 100 times. Oh, I'm sorry. 382. All right. So this can go back up on the board. Do you all need a couple of minutes?
We're ready.
Paul, did we disrupt that trial for this? No. All right. So why don't we bring them back? All right. So is everyone in agreement with that? Yes.
Yes.
Okay. And then that happened. Now, who is this? Becker?
Becker. I remember him being so nervous, at least in the second trial.
Mm-hmm.
So like sweaty, nervous. I was very nervous for him.
Yeah. Well, buckle up.
What, if any, duties or responsibilities do you have in regard to writing a report?
It's my report. That'd be right.
May I approach the witness?
Yes.
The documents is that to review that with us.
The first report up here is the engines. Second one would be mine.
Do you recognize the first few pages of that as the engines report and the last few are yours, correct?
Correct.
And that's your report with relation to this dispatch and this call, correct?
Correct.
Can I approach again, Your Honor?
Yes.
I want the chief to introduce in a minute the next.
So both reports through this witness? Is there any objection?
Yeah, just take a look at the DA's clock.
So again, I don't know why I'm apologizing for Bev so much today, but we always say that she asks the Commonwealth if they want to object. And that time she turned to Yannetti and was like, do you have a problem with this? And he did. He objected.
Yannetti, Your Honor, my only issue is that he has testified that the engine report is not his. He did not write it, so there's no authentication for that. I would not object to his own report going in.
Is it the same as you gave the last witness?
Well, only to refresh his memory.
I understand. I don't think anybody realized there were two separate reports before that. Who authored the other report? Mr. Lally, do you know? I believe it would have been, I'd have to look at it, but either Lieutenant Woodbury or Firefighter Pock, which is two like separate agencies. Okay. One or the other. All right. Would this witness know? I think I have a feeling that he might not necessarily offhand. All right. So I'll allow his report in. If you need to call Woodbury for just that point, I don't think so. All right. And before you go, do you want to mark the other report for identification, Mr. Lally? The first part? No.
It's so wishy-washy. Like, he said so many wishy-washy phrases in 2 lines. I think maybe not necessarily, perhaps, I'm not sure offhand. I'm like, God, just say you don't know.
Like for him to be saying like it was either Lieutenant, I don't understand what's happening. Anyways, okay. Okay, so now there's another, now we have to watch him be nervous again. Hold on, is that right? Yeah. How did I do this last time? I just kept switching.
Correct?
Correct.
Your memory of what Karen Reed told you about whether she had anything to drink the night before would have been much better on February 14th of 2022 when you were talking to Trooper Michael Proctor than it would be today, correct?
Correct.
Because your memory doesn't get better over time, correct?
Certain circumstances, sure.
And with regard to whether Karen had indicated that she took any drugs, you told Trooper Proctor she said that she had not, correct?
Correct.
With regard to whether she had had alcohol the night before, you told Trooper Proctor on February 14th of 2022 that she did consume alcohol last night, correct?
Objection, Your Honor.
All right, I'm going to see it.
Okay. So what is the objection? Your Honor, essentially counts. And the reason why I put that clip in is because what he says now is absurd. Your Honor, essentially counsel is just reading from the report without any sort of indications from the witness that his memory is exhausted as to that or what he told. He is reading Trooper Proctor's report and asking him if he agrees with it. Okay, the objection is overruled. You can do that. And that was that.
I love it from the court. Yes, a little fight for the proper evidentiary ruling. She's like, enough, Lally.
Yeah, she's like, Mr. Lally, that's what you're supposed to do, Lally. Like, you should do that too. Hold on, my light is doing this thing again. Actually, let's take a 2-minute commercial break so I can fix this thing that keeps falling. Here we go. Meticulous evidence collection was vital in finding out what happened to Miss Riley. We carefully photographed all aspects of the scene in order to preserve the evidence as it was and to be able to reconstruct the crime. Nothing like this ever happens in Canton, so we got to play pretend, like when I play cops with my nephew. We pretended that red Solo cups were the evidence containers and that a Stop and Shop bag was the evidence bag. And I even got to go zzzz with a leaf blower. And the auditors thought that was a really good idea because I found a clear glass in all that snow. We obtained surveillance camera footage, which was critical to establishing a clear timeline. Subsequent analysis of Mr. Hernandez's phone records aligned with the video timestamp. Sometimes investigators need ring camera footage to figure out what happened, but that's because they don't have Trooper Paul. We brought Joe Paul to 34 Fairview, and the whole scene just told him what happened. I secured the area with crime scene tape in order to prevent the contamination of potential evidence. No, I didn't guard the scene. It was snowing. Everyone was just cozy at home watching Harvey Leonard and Cindy Fitzgibbon. Plus, it was little Brian's birthday, and he has anxiety. I didn't want him to be scared when he looks outside. That was fun. Okay.
Wait, who are the people that you referenced that they're watching on TV?
Harvey Leonard and Cindy Fitzgibbons. They're our weather people.
Oh, got it.
Those are for the locals.
Love it. Love the local details. You know I
do. Okay. Now we're on Nicole Albert. And you guys, if you ever want a testimony to go back and revisit, I cannot recommend going back to watch Nicole Albert's entire testimony because I don't think I realized how like she was rolling her eyes at everything. She was like so confrontational. She's laughing at Yannetti at like half of the question, or at I think Liza Little's actually the one who's questioning her, laughing at half the questions that she asks. Every time that something gets objected to, she literally giggles. And everything she says sounds sketchy. So here we go. Wrong one. I need to figure out how I can just play videos from the slides.
It looks like you are, or from what I see, that's what I think it's happening.
It's not.
Robert, when your husband drinks, does he often
So I'm sorry, are we taking this down or keeping it up?
Yes, Your Honor, you can take it down.
Okay, thank you.
Okay,
Ms. Albert, when your husband drinks, does he often get into sort of these practice sparring, practice fighting stances? Is that common for him?
Objection.
No, I'm going to allow it.
No, I don't think so.
So this type of behavior was unusual for him.
No, I think they were just fooling around. I don't think there was anything much to it.
My question was, is it unusual for you to see him sort of practice fighting?
I wouldn't call that practice fighting. I think they were just fooling around. And yeah, maybe I've seen him do that other times, but it was fooling around. They weren't practicing.
Let me put this a different way. You do know that your husband is a highly trained fighter, correct?
Objection.
I'll allow that.
Absolutely not.
Your husband has no fighting experience whatsoever?
A highly trained fighter? No, he's not.
He has boxing experience, correct?
Objection.
So I'm going to see you at Sidebar on this, please.
Haha, that was so funny.
Where did they get together on the absolutely not? Like it is, it's so bizarre to me how often everyone says it. It's such a weird thing, so dramatic.
Absolutely not. Mr. Lally, what is the nature of your objection? And then I'll hear from you. Relevance?
This is I feel like Eliza Little wears a lot of like Tory Burch suit blazers. I'm not positive because I don't recognize a ton of them, but I'm going Tory Burch in the hopes that that is her fashion inspiration.
It feels like the vibe.
Right. Your Honor, this is highly relevant. This goes, first of all, to the witness's credibility. It allows the jury to evaluate the circumstances that occurred that night right before they went to 34 Fairview. This witness has just stated that her husband has no fighting experience whatsoever.
Well, no, I think she said that he was not a highly trained fighter. I disagree with the Commonwealth. This is relevant, just the wrong witness. Brian Albert is the next witness.
I just have two more questions.
What are the other two questions?
I want to ask her if she knows whether her husband has a lot of training in boxing and whether he is highly skilled in fighting from being in the military.
I think you're going to get some pushback on the highly skilled. I think that's what the problem is.
I'll just ask if he has just any general training and experience.
But he's the next witness. Can you explain why you need it from her? You started out by saying it went to her credibility.
Well, she's just testified under oath that he has no experience, and she was reluctant to agree to the boxing as well.
That's not what she testified to. I think what she hesitated to was the highly skilled. She gave you the boxing. Why don't you ask those two questions?
Thank you, Your Honor.
Why don't you ask the two questions you just said you wanted to? Okay.
The
So
pre-screening all of the questions is so bizarre to me on stuff that's not very controversial. It's just tell Lally what you're going to ask so we can start thinking about his objections now. He needs a 4-minute head start.
Mm-hmm.
Albert, when your husband drinks, Ms. Albert, you don't have Chloe anymore, do you?
Nope.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
So is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Your dog is no longer in the Canton area, correct?
No, but I know where she is. She's in Vermont. And that previous testimony, that information has all been given. So if she was ever needed for anything, we know where she is.
Was that testimony given to the defense?
Probably.
Was I present at the hearing where you testified about this?
Objection, Your Honor.
Sustained.
Look at that face. Her face there was rude.
Yep. And it's funny that the prosecution's witnesses are the ones that are sort of revealing the prosecution's lack of forthright sort of explanation of what they were doing. I'm trying to say this in the nicest way possible without accusing anyone of doing anything, but the prosecution's witnesses are telling on the prosecution, and I find it hilarious and sad at the same time. Anyways, Miss Little, I want to ask her a question about, the nature of testimony. Obviously, this was in front of the federal grand jury. I don't want to overstep. I believe she's trying to reference that, but I don't want the jury to be left with this false...
You're talking pretty loudly. This is to Liza Little. You're talking pretty loudly.
Sorry, I didn't want the jury to be left with the false impression that information was provided to us.
So it was provided to you. Where is this testimony? It's in the federal grand jury minutes.
But not by the Commonwealth.
Oh, I'm not going to split hairs on that. What difference does it make? So I'm not going to allow you to get into that. She said she testified about it, and you were aware of that.
Okay, thank you. May I have one moment?
Sure.
She's saying we weren't aware of it, and Lally's like, you were. Cite to it. I guess she's saying it's in the federal grand jury minutes. Obviously, they're not aware of it. Did she testify at the federal grand jury? I guess I don't know one way or the other, but...
Well, now we know she did.
Do we for sure know that, or what? Was Lally just saying that? I didn't see a cite to chapter nurse.
Good point. Well, I assume that's where Liza found out this information, but who knows?
Who knows?
And the very last person to leave your house that night, you said today, under oath, was your daughter, Caitlin, correct?
Yes.
And you said she left your house close to 2 a.m. Is that right?
Yep.
Ms. Albert, that's not what you told Sergeant Lank on January 29th, 2022, is it?
I don't recall what I told him.
Would it refresh your recollection to take a look at your statement to Sergeant Lank?
Sure.
May I approach the witness, Your Honor?
Yes.
Okay. I'd like you to take a look at page 2.
Mm-hmm.
And you don't need to read it out loud, but if you could read this very last paragraph here.
Down hit 7. Or
Actually, this section right
Okay.
here, the second paragraph to the bottom.
Mhm.
You don't need to read it out loud, just look up once you're done.
And are you going to clarify that, Ms. Little? Statement?
Oh, how can I approach, Your Honor? Ms. Albert, this is just a police report containing an interview that was conducted, correct?
Yep.
With Sergeant Lank on January 29th, is that right?
yes, the morning of.
Thank you. Have you had a chance to?
Yes,
Is
yeah.
Is your recollection refreshed?
Yep.
Isn't it true that you told Sergeant Lank that your daughter left at 12:15 on January 29th?
I do not recall saying that. I've maintained in every interview testimony I've had that she was the last to leave. So I don't know, it was very confusing that morning. Officer Lank was trying to ask everybody, where had you been? Where had you been? When did you get here? When did you leave? I don't know if somehow it was misconstrued, but I've always maintained that Caitlin was the last to leave.
Understood. And that's because Sergeant Lank was talking to everyone at the same time, correct?
Yeah, I mean, we're sitting around the table. It was a little, everyone was, we're all in shock and it was a little confusing.
Sure. It was more of a conversation than an interview. Is that right?
I guess you could say that.
May I approach?
Yes.
Ms. Albert.
I'm going to stop that one. But I forget where there's a sidebar coming up, but that was enough. We get the point. Okay. I forget where that was hit. I forget where that one stops. Obviously, this is Lally objected. Obviously, Attorney Little can show whatever she likes to the witness to refresh her memory if that's what we're doing here. But when she refers to it as her statement and then shows a police officer's report, I just don't want that to be misconstrued as far as what she is showing the witness.
I apologize. I won't do that again.
Okay.
I'm not totally sure what he is suggesting the confusion was. I thought she was quite clear that it was a police report and it was used to refresh. I mean, maybe she shouldn't have said it was a police report, but saying if it refreshed her recollection, that would be normal. And by the way, this whole time, Bev is like criticizing the defense for asking different witnesses about things that relate to other witnesses who will or did testify. And like, this is a great example of why, because when Nicole Albert testifies about Lank's observations from that day, and they are quite different from what Lank put in his report, it matters. It shows that his recollection is different. They can, suggest why it's different, whether he just makes a lot of mistakes or he put something down improper, whatever. But you got to have testimony from someone else to actually draw that information out. It's important.
You would think. And yet, here we are. Also, I'm realizing I hate this time of day where we're in the same time zone and it's pitch black here and you still have full daylight. God damn it.
Why is it so dark, pitch black? Is it really?
Yes, because it gets dark here so early. And this is why I hate daylight savings time. And I could do an entire hour just about how much I hate daylight savings time. But yes, the sun sets at like 4:20 now.
Yeah, we're a magic hour. Everyone go outside and take your pictures.
Yeah, everybody go outside in Boston now and use your night vision.
Ms. Albert, what's the first thing you remember waking up to on the morning of January 29th?
My sister bombing into my bedroom.
Okay.
Just a reminder that you just said bombing into my bedroom. And then in the next trial, they try to say like, oh, Jen just like tiptoed in. Oh no, I just messed that up.
Ms. Albert, what's the first thing you remember waking up to on the morning of January 29th?
My sister bombing into my bedroom.
Okay. Your Honor, if we could approach.
Okay, approach sidebar. Or you okay?
Yes.
Okay. Why? Okay.
All All right, Miss Little, I'd like to be able to show the witness, this demonstrative. It's 34 Fairview, the crime scene photos. As you've seen, they're not the best. This is an actual replica of 34 Fairview. It's to scale.
Keep your voice down. Again.
It's to scale. I think it will assist the jury of being able to determine where certain things are on the property.
Mr. Lally, the objection? As I told Miss Little, as long as the witness can recognize it and adopt it as representative of her home, then I have no objection. So basically, you should have waited. All right. So you just want to use it as a chalk instead of an exhibit?
Yes, Your Honor.
Okay.
And do I have permission to publish this to the jury?
Is there an objection to that, Mr. Lally? Assuming the witness adopts it? No. Okay.
Okay, thank you.
So basically, he should have just waited and seen what happened. And guess what? She adopts it because it's literally a picture of her house where she lived, and she knew what it was.
Ms. Albert, what about...
Sorry. Where are we? Ah.
Ms. Albert, what about the 2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
You're aware that the Celebrate records indicate...
Was there one before this? Did I just mess that up?
Ms. Albert, what's the first thing you remember waking up?
Okay, we're back on the phone calls.
Ms. Albert, what about the 2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
You're aware that the Celebrate records indicated that you answered 2 calls from your sister.
Objection, Your Honor.
And 6:08 a.m.
The objection sustained.
Your Honor, may I approach the witness?
Okay.
If you could take a look at this report. Ms. Albert, do you recognize this document?
Recognize it?
Do you know what it is?
Well, yeah, I see what it is.
Okay, now that's very important. She does know what it is. Now Lally objects. What's the objection? I don't know how this witness is supposed to authenticate a Celebrate report of someone else's home, which is not what a Celebrate report is. What is your question?
My question is just, does this refresh your recollection as to the 2 calls you received at 6:07 and 6:08, which were answered?
But you incorporated in your question that she answered them, right? And she said no.
Mr. Lally used a Celebrate report with another witness yesterday.
The Celebrate, are these reports in evidence? I don't have any objection to them coming into evidence, but no, they are not in evidence. So ask her if she recognizes it, the question she just asked, and if it refreshes her recollection as to only calls not answered, anything like that, and see if it does, and we'll likely take a break after that.
Okay.
Now we're back. This is on recross, I think, and they're talking about Chloe again. Okay. And they have a sidebar in that. I maybe should have put something. Okay, so Lally says, Your Honor, so over the luncheon break, attorney Gregory Henning was here with both Mrs. Albert and Mr. Albert, who are his clients. This is what I was saying. We get some juicy stuff. My understanding is it's the first time I'm learning this is that apparently there was some meeting that he had with the U.S. Attorney's Office in which they provided documentation related to them to the U.S. Attorney's Office. So I think when the witness is answering this question, she is answering in regards to that. Nothing has ever been turned over to my office or myself, which makes me think it had. So before we go down that road and into that, I think that's what a truthful answer would be to this. And obviously, based on the Commonwealth's motion in limine to exclude any reference to that, I just wanted to cut it off before we get there. I also don't think it's relevant in any way, shape, or form.
This is obviously the first time we are hearing about this. We've had motions in court regarding this information for a long time.
Do the two of you want to talk for just a minute? I'm not inclined to allow this questioning based on the representation of Mr. Lally.
I just don't want to leave the jury with the false impression that...
You've asked the same question 4 times after I sustained it twice. I understand. I'll let you, Mr. Jackson, talk with Miss Little for 2 seconds.
2 seconds. Can we say... Yeah, literally. Can we
literally
suggest...
like one Mississippi?
I know. This is wild, by the way, that they're like once again finding out new information that they sought in pretrial motions, and that if I recall, the court didn't let them have. And I don't know this exact whatever they're talking about, but they've already addressed this.
I think this is also. I think this is a follow up about Chloe Cora being in Vermont, and I think they talked to their lawyer, and they're saying. I believe that they're saying we know where Chloe Cora is if they ever wanted Chloe Cora.
Chloe Cora. Okay. Can we suggest a stipulation that she's never provided that information to the Commonwealth or the defendant?
But I don't know that she has that obligation. That's a whole different line of questioning. Do you want to stipulate to that?
And no further questions.
I don't know why she just says no. Okay. For that reason, I think it leaves the impression that she somehow was hiding something, or she was never ordered to provide or never even asked to provide anything. The issue I would have with the stipulation is it's all right. I'm going to end this inquiry right now, I guess. Okay. Thank you, Your Honor. Wait, now we're at, hold on. Oh, okay. So now we're moving on to Brian Albert, which, hold on one second. I thought I had a picture. I'm a little lost. But anyway, so Brian Albert's direct finishes, and it's 3:50, and there's a sidebar about scheduling. That gives, and they talk about scheduling for a while. I cut that part out because it was boring. And then Bev says, that gives you another long weekend, as if she doesn't also get a long weekend, which she loves.
That's great, says Yannetti. Mr. Jackson, the other procedural question I mentioned to Mr. Lally, and I figured we might as well make use of the time. There's one exhibit that I was considering using. I am considering using. It's not been marked. Mr. Lally has it. It is a video.
Did you give it to me? Okay.
The court has it. It's a video of no sound of my investigator and me at the bulkhead, walking to the back gate and then to the front yard.
Yes, I can tell you the concern I have.
Tell me.
You can't be a witness.
No.
You are in that video. You are in both of them. When I saw those last week, I can't let them into evidence, even if Mr. Lally agrees.
He doesn't.
For the same reason.
It's not a perfect scenario. I think we could overcome that if push came to shove, because I did have, I'm smart enough to have a witness with me. Mr. Mikowski was with me, and it was videotaped.
You should have been videoing it, and he should have been in it.
Probably, but I didn't. So I just wanted to take the court's temperature on it. I'm not married to it. If the court's not comfortable with it, I can parry and use some still photographs.
Especially with the objection, but when I saw it, I can't let it in.
Understood.
Okay, so I'll make these dated and announce to the jurors.
That would be great. Thank you, Your Honor.
Thank you. Okay, that picture should have been before. Now I'm not lost anymore. So now this is the next day. Brian Albert is starting the morning off, and cross-examination is like first thing, bing, bang, boom. That was nice timing. Before he enters, they have a sidebar. All right, are we all set to begin?
This is similar to the video that both counsel and the court ended up indicating they have an objection to the bulkhead to fence to front yard. I had my investigator go back out. Now, the court had indicated that we should have done it with the investigator and nobody else was in it. We did exactly that. All it is a video from the bulkhead. He opens up the bulkhead door.
Is there sound? Is there audio?
There's no audio. The audio has been stripped.
He's like, I did exactly what you wanted me to.
And he didn't talk on it anyway. I wasn't there. He took the video from the bulkhead. He turns, walks to the fence, goes through the fence, and walks to the front yard, and that's it. It's probably 15, maybe 30 seconds long.
It's 51 seconds long, Your Honor. The objection is, and obviously this is within the discretion of the court, but relevancy grounds, I don't know if any witness that puts Mr. O'Keefe, I don't know of any witness that puts Mr. O'Keefe in the house, let alone in the basement, in the area of the bulkhead, or anything to do with that. So for that reason, the Commonwealth would object on relevancy, as it really is just to confuse and mislead the jury about whether or not Mr. O'Keefe. There is no indication that the bulkhead is at all relevant, as Mr. O'Keefe wasn't in the house and wasn't near the bulkhead.
Well, that's their theory, that he wasn't in the house.
Explain the relevancy.
We believe that there is evidence that Mr. O'Keefe was in the house. There is strong evidence that he was in that house. That's probably coming up either today or tomorrow.
Make an offer of proof for me.
Your Honor, Ryan Nagel and Heather Maxson both saw John O'Keefe. They both saw John O'Keefe and Karen Reed in the car together when they turned almost simultaneously onto Fairview from the adjoining street to the north. When they pulled up, both witnesses will testify that based on looking at their phones, they started paying attention to the house. It was Julie Nagel who started to make her way out of the house. They were there for about 5 minutes, 10 minutes talking to Julie Nagel. Julie Nagel then goes back into the house, decides to stay. She doesn't want to ride home. And as they leave, both Ryan Nagel and Heather Maxson indicate that they looked into the interior of Miss Reed's SUV. John O'Keefe was not there. Miss Reed was sitting alone with nobody else in the passenger compartment. They will both say they did not see him standing outside the compartment. He wasn't on the street. He wasn't on the sidewalk. He wasn't in the yard. The only other place he could have been is in the house. And if he was in the house, then there was reason to believe he was in the basement. There was an exit from the basement to the backyard, serving the very area on the same side of the house where John O'Keefe's body was found. That is the defense's theory. That's been the defense's theory from the beginning. The Commonwealth has a different theory, that there is 7 witnesses, 9 witnesses, all of whom walked out of the house or in the same way looked out of the house, and no one saw John O'Keefe's body on the lawn, which is where they claim he would have been at the time every single one of those people passed by the lawn or looked out onto the lawn. The only other place he could have been is in the house.
And what about him being in the house? If that's true, then what? You need to give me some more. What do you mean? If he was in the house, then he didn't get hit by a car, Bev.
If he was in the house, then the most reasonable place for him to be and be injured is down in the basement. There is a slab flooring down in the basement that's made out of concrete. That would answer the question how he got the fracture on the back of his head. The lacerations to his eyes, the black eyes, the bloody nose will indicate a fight. Now, we've got evidence and we've got experts who are going to say that he looks like he was in a physical altercation, not hit by a car. And if he was in a physical altercation that nobody else in the ground floor saw, the only other place he could have been is upstairs or downstairs, such that they would not have witnessed the actual fight or the physical altercation. The most reasonable place for him to be is down in the basement. And the basement services the very side of the house where John O'Keefe's body was found. We would want to be able to show that and establish that the bulkhead is a place where if you wanted to remove something large and heavy, you could easily do it. And if you did do it, that would end up right on the same side of the house where John O'Keefe's body was found.
All right. So apparently there is a third-party culprit inside the house.
Correct.
And who might that be?
This just cracks me up. I'm like, yeah, you're dying to know what they're gonna say and show their hand to Lally. Give me a break. Okay. Jackson. It's unknown. It could be one of several people.
So, under the third-party culprit doctrine, I do think this is speculative, but I am going to let counsel explore this. So I am going to let the video in. I understand. Okay. So the Commonwealth's objection is noted, but he has to authenticate it.
Understood.
This wouldn't pertain to you guys, but Mr. Carney's in the courtroom. He cannot view this witness, correct? Correct. Okay. So we will bring the witness in and he's going to be removed. All right.
Thank you.
I just love that they're like, guys, Turtle Boy's here.
Jim, just getting in there.
Just want to let you guys know I can see Turtle Boy. I am scared. Okay.
Isn't it true that you were asked the question whether or not you knew Karen Reed on January 28th, 2022, and you testified, quote, "I've never met or seen her before," end quote.
No, I don't recall that.
Didn't you indicate that you just testified, that you reviewed your grand jury testimony in anticipation for this trial?
Yes.
You'd read the whole thing?
Yes.
And you don't recall making that statement?
No.
Mayor Pro Tem?
Yes, and I'll see counsel at sidebar.
Oh no. It stops at slide 100. What do I do? Oh goodness, you guys.
Wait, there's more.
I know there's a ton more. Okay, wait. We're going to do another commercial break and then I guess I have to delete a bunch of slides.
Oh no, sad.
I know. Well, no, I'll make here's what I'll do. I'll make a copy and then, okay. Commercial break, you guys. I have some, our commercial breaks now are going to be inspiration for retrial sidebars because that's what I'm really excited for. I've been training to be Hank. Meticulous evidence. Nope. Did that one already. Remove. See all those superficial abrasions? Yes, I see all those dog bites. Please stop saying that. Can medical professionals disagree about opinions on wounds? I suppose they can, if they're not as smart as me. Do you agree that the brain is very soft, like tofu? Oh, gross. Hey, you relax. Is it that soft? I guess it depends what kind of tofu. Do you know how tall John O'Keefe was? 7 foot, 5'11", 7'2". Oops, I'll say something dumb too. Spoiler. Did you look at any data that would tell you what the speed of the impact might have been? Well, it didn't hit him, so that doesn't matter. So you didn't even care to know how fast or slow Miss Reed might have been going? It didn't hit him, so whether a car was going fast or slow is irrelevant.
Damn, it feels good to be a gangster.
Yeah, that was bullshit. I looked at the x-rays and there were no broken... That's why we moved for a mistrial with prejudice. Denied. Psst, what was he even talking about? Mr. Alessi, really, what did you think was going to happen? I deny the motion and Attorney Brennan can add 3 extra pieces of evidence because you wasted my time. defense team? At their hotel. Ooh la la. I mean, it was in a conference room. Fancy Hollywood lawyer has a fancy conference room, am I right? The Holiday Inn has a conference room. Do you remember what you wore to school the first day of sophomore year? Objection. Yoo-hoo. So you, as is in your nature, have problems with your memory. I know what I saw, and that wasn't it. Way, did someone tell you you should ask for a transcript? Yes, Mr. Lessie, when we were driving in the car. Were you holding hands with him? No. Can I see the transcript now? It doesn't exist. Moving on. Nails on a dog are horseshoe shape. I don't even know what that would look like. Maybe you should ask your friends in your dog bite community. In scissor tooth. I'll ask you one more time and then I'm coming up there. Did you see a video when Dr. Welcher put blue paint on his arm? Yes. You mean there isn't a methodology for identifying dog bites? Mr. Brennan, usually the methodology is saying to a patient, did a dog bite you? So you're saying there's no standard for identifying dog bites, and therefore nobody has ever been bitten by a dog, and therefore John was hit by Karen's Lexus. Do you have any memory issues? Oh my goodness, this is not being my friend right now. But I think we're gonna, okay. I'll just do it from the slides. And then I don't have to keep switching back and forth.
I feel like it's seamless when whatever you're doing looks like it is all together.
Well, good. It doesn't feel like it, but I think this might be better in the end. Let's see. Stop screen. Whoa. I'm always scared. I'm just going to like close everybody out or something. Okay, let's see. Add to stage. Woohoo.
Yes.
Okay. I don't know I don't know what's happening right now, but let's just start there and we'll find our place.
Great.
Okay. So I allowed the motion to stay away from the federal grand jury, and we were here at Sidebar. I instructed Mr. Yannetti that he could say the grand jury, different date, and Mr. Lally wasn't there. Do you want me?
Is that not accurate? It's non-grand jury.
But it gives the impression I have already ruled on it.
All right.
Well, that's why I'm telling you.
Okay.
So it's grand jury date. And I'll let you get into Mr. Lally wasn't the prosecutor.
If I'm consistently asking about both grand juries, can I say the other grand jury?
Yes, just not Commonwealth.
Okay.
Okay, now they're talking about, oh, that's why they're getting into grand. Oh, you know what I wanted to ask you? I had a brain fart when I was going through all of this, and I cannot remember. How do we know that the 222 call happened between Higgins and Brian Albert if both of them destroyed their phones?
I don't know.
Oh, okay. So I wasn't just having a brain fart.
No, I have thought about that other times, and maybe that comes out in their testimony, but Higgins said that he only preserved text messages with John and Karen, and Brian Albert destroyed his phone. So is it, I don't know. That is a really good question.
Okay. Well, then that makes me feel better because today I was like, wait, like we must have found that out at some point. But so then if they have someone said the phone records from Verizon, but if they have phone records from Verizon, then is it the feds have their phone data? Like, is that where this came from? From like the oh, so they have phone logs, but not texts?
I mean, yes, the phone company does have them, but who got them? It was because as from the FBI. Okay, well,
So
there you go.
Well, then that made me feel better that maybe they have more than we even know about. Like people have said, like, oh, there's no way to like get the data at this point. But that it did make me feel hopeful that like those records do exist somewhere. Someone said their butt knows. I like that. Okay, so they're asking Brian Albert about the fact that he destroyed his phone after he got the preservation order from the Commonwealth. And they have a sidebar about that. So the nature of the objection, Your Honor, again, I think it's relevancy and hearsay. That's all.
I gotta say, it makes me laugh when Lally does his objections because he's like, "Oh, relevance, hearsay, like the two most obvious, easy layup objections." Maybe
it feels like a 1L student in law school who gets called on in a big whatever you call it, like seminar, and is like, it's relevancy.
I remember my first trial, I forget what it was called, trial advocacy class or whatever. We had like a fake judge standing in, and I didn't totally understand hearsay. We had just learned about it, and I it's kind of a hard concept to wrap your head around practically. And I remember the judge, I objected to something, so I was like, something ain't right, but I wasn't quite sure what it was. And the judge is like, and that's because this is, and I'm like, hearsay? I just have this like very clear memory of just totally guessing and saying like evidence words and hoping one of them was right. And I feel like that's what Lally does every time he objects.
Yes, that's him 18 years into his career.
Oh my God. Okay. That was, yes, at the very beginning of my law school career. Hearsay, maybe? Relevancy and hearsay. Okay. Jackson.
It's like, that's all.
That's all. And Jackson's like acknowledging that this is a hearsay objection, and therefore he is asserting a hearsay exception. So Jackson says, it goes to his state of mind, Your Honor. The Commonwealth actually was the entity that gave him notice that he was not to get rid of his phone or any of its electronic data. His state of mind, and he did so anyway, notwithstanding that notice, is highly relevant. He's been questioned.
Is he going to have to talk about he did this with the advice or consent of his lawyer?
I have no information about that. I can tell the court he's testified to this before and he never mentioned anything about that.
But I'm wondering if that's part of it. I know he didn't mention it before, but I'm wondering if that's part of it. He's got a lawyer here. I don't know. Okay.
I would maneuver around that. If he says, I had a conversation with my lawyer, I'd say, don't tell us anything that your lawyer said. It's not up to his lawyer to thwart a judicial order.
You know what? I want a short voir dire on this.
Okay.
And we can bring his counsel in if he's here.
Can we wait until he invokes his counsel? I don't think he's going to.
Let's have a voir dire on this. I'm going to send the jury out, but that's the issue on this.
Okay.
Jurors, we're going to send you back to the jury room for a few minutes. And now we're in voir dire.
Yeah, we got to give Lally the answers to the test before he actually gets to it.
Exactly. And we need to wink, wink, nudge, nudge somehow to Brian Albert. Hey, you should probably ask for your lawyer right now.
Yes.
Did you get a subpoena for the other hearing?
I did.
Okay. Did you hire Mr. Hinning after you got that subpoena?
I can't say, I believe so, right around that time, yes. Okay. I'm just trying to remember the time, and I can't remember it.
Okay. So you did not hire, well, Your Honor, I think that answers the question. You're not represented in court.
I'm going to see at sidebar about the extent of the inquiry.
just so we can complete a record. So if you put the dates on and your concerns, I'm have a concern about a Fifth Amendment issue. He's got a lawyer. If he's going to sit here and say, I was told I had to keep my phone and I didn't do it. So let's lay out the dates and have a more complete record.
Yes, Your Honor. The dates, as I know them, is the subpoena went out for the, I'm gonna continue to call it the other grand jury.
I think we should call it another proceeding. And then that will differentiate it with the jurors as well. I think that was my original ruling on the motions.
Okay, the other proceeding subpoenas went out in the spring of 2023, maybe the late spring of 2023, at which point many of the individuals, again, giving them lawyers, they did not have lawyers that I know of in April of 2022 when they testified with Mr. Lally at the state court grand jury. This particular incident, this particular notice was signed by Judge Krupp on September 23rd, 2022. And I believe his testimony is going to be something along the lines of, toward the end of that month, without a specific date, he got rid of his phone in September of 22. Well, before he would have had any opportunity or reason to hire Mr. Hennig.
Okay, so it wouldn't have been after consulting counsel, but there is still the Fifth Amendment issue now, right? Not a court order.
I agree.
So I'd like it if you intend to do that question, I'd like you to do that for purposes of voir dire.
Okay.
Just in case his lawyer says he should take the Fifth.
Understood.
All right.
You know, I was thinking this is like a little aggressive in terms of defending him for something that he hasn't invoked right to counsel, and he hasn't, from what I can tell, Brian Albert hasn't actually raised this as a concern. And it would just have to do with destroying evidence as a witness. But that's the same thing that Jackson, isn't that how Jackson essentially won the Kevin Spacey case in Massachusetts as well, by the victim, alleged victim, invoked right to counsel, and his mom maybe had destroyed some text or whatever. Like, it's the same thing. I'm wondering how much this makes me think Bev knows every single detail about that proceeding as she came into this, because it's just a little like far afield to assume that a little bit.
Interesting.
I don't know. Just a thought.
That's really interesting. Yeah, because that got dismissed before it even ended up going to trial. It got dismissed in those like pre-trial hearings about the phone for like this literally exact reason.
Right. Yes, I watched I think Nurse Kim did like an episode on the that proceeding, which I watched, and I was like, oh wow, that would explain why people in Massachusetts. Who?
Court Chopped did the video of that.
Got it.
Yeah, that's a great connection. I did not even think of that. That is yeah. Well, and she just feels like she's protecting Brian Albert here in general, where she's like, he might want to plead the Fifth. Like, does somebody want to tell him to? So now Jackson has the letter. He got permission or something to read the letter from the Commonwealth about preserving the phone. And this is the end.
You are hereby placed on notice that these cell phones are the subject of pending litigation, and you must not alter, delete, destroy, or in any way manipulate any of the electronic data associated with the cell phone at issue. You received, end quote, you received that notice on either the 23rd or the 24th. Is that right?
I did not.
Honor, I would pose a stipulation. I spoke with counsel off the record, if I may.
You both have a stipulation that I haven't seen?
We just determined I'm happy to approach it.
Why don't we approach?
Bev did not. She feels like they went behind her back. What is the stipulation?
Your Honor, Mr. Jackson or Mr. Lally was kind enough to confirm that he and his office did send this notice either on the 23rd or 24th of September.
Okay, so that it was sent, but not that it was received.
Correct. I can't make him read it. They don't have a copy of the letter that was sent. I think a stipulation is cleaner. I simply want to enter into the record that the Commonwealth sent it. If he claims he never got it, so be it.
It's almost like they should send these like notarized or whatever, where you have to like sign for it. Okay, so what exactly was the stipulation? What are you going to say?
I would propose that the following stipulation, that the Commonwealth, either on September 23rd or September 24th, 2022, sent a letter on Commonwealth letterhead stating exactly what was just read into the record.
Okay, don't read it again.
I won't. No. That was just read into the record, was sent to Mr. Higgins. I'm sorry, to Mr. Albert on either the 23rd or the 24th.
Okay, that's the stipulation.
That's it.
That's fine. I don't have an issue with that. Okay.
Thank you.
Okay.
So, Mr. Albert,
and I think now we're back the voir dire is over. Now we're back with the jury.
you missed the call 17 seconds later.
Well, my wife was in the room with me and we were hanging out and I never got the second call from him. So I'm not sure what time he called. I'm not sure what I was doing at that second, but I don't know.
But it didn't go to voicemail.
Well, I didn't get a voicemail from him. No.
So it didn't go to voicemail.
Well, I don't know that don't know that it didn't go to voicemail. I just know that I didn't receive a voicemail from him.
So if you, okay.
I mean, we're all guessing here, but I mean, he could have called voicemail.
We're not all guessing.
Well, you are, because you don't know if he left a voicemail or didn't, or at least got voicemail and then hung up the phone.
I think one of us is trying to guess.
Objection, Your Honor.
Sistine. You know what? I want to see counsel sidebar.
Now, that part with Jackson actually did kind of annoy me, because it's like, how many times have you called somebody, gotten voicemail, and then hung up because you got the voicemail and didn't leave a message? Like, that is
Literally
also
every
an option. Yeah, like that is also an option. And the fact that Jackson kept being like, either like you leave a voicemail or you hang up before voicemail and there is no other option, that drove me a little crazy. But now Bev is Bev's mad. Hold on. You would think this would be a good one, but it's actually the shortest one that there is. Bev just says, I'm giving you a lot of leeway with your questions. Please calm down.
Yes, ma'am.
The end.
That made me laugh out loud.
Like, do you think that made Alan Jackson calm down?
I don't think it did.
How many times in the history of the world has somebody calmed down because somebody told them to calm down?
I, from personal experience, can't think of any.
Okay.
I think Jackson did so much commentary in the first trial. I feel like he was a lot better about it in the second trial. It was unnecessary. And I could see his commentary in the first trial being enough to turn the court against him, because it was a lot. But I think, as we all know, the court was already not his biggest fan, to say the least, during the first trial. But he reined it in significantly, I think, in the second trial, in my opinion.
I would love like a little talk bubble above his head of what, all the commentary he wanted to say in the retrial and didn't.
That would be incredible.
There are a lot of phone calls being made to a lot of people because of this horrible situation.
And the point is, Mr. Albert, those many calls that you've just described, especially as they pertain to Brian Higgins, Jim McCabe, Kenny Berkowitz, your brother Kevin Albert, were those many calls an effort to get stories straight at the time?
No, absolutely not.
Were those many calls an effort?
I'm going to interrupt you, juror. We're going to send the jury out.
So something happened with the juror. I don't know exactly what. We got to hear from Victoria. So a juror needed to leave like immediately. And
okay, Jackson, I wish I had told you. I have 2 questions left. It's okay. It happens. Thank you. I appreciate it.
And then they come over to sidebar as quickly as they can.
I get it. I've got 2 more questions and then I'm done.
Great.
Thank you, Your Honor.
We will take our luncheon break.
Oh, I wonder what that was.
Yeah, I don't, maybe someone was nauseous or something. That's like literally, maybe when Victoria was nauseous. She was pregnant with twins.
That would be reasonable. But what did he wish he had told the court?
Yeah, I don't know. And why does she always call it luncheon? Why can't it just be lunch? Okay, so now Brian Albert is done. And we're just sticking with the Albert family. And we are at Brian Albert Jr., the birthday boy, man, child. And his big bad Brian Albert in his Mr. Rogers outfit went home. And now his son in his Mr. Rogers outfit came to take his place. And this is a sidebar where they were asking, okay, so there was a back and forth about what Brian Albert Jr. had told the grand jury about when he looked out the window and saw Karen's car, and then he went back and then he looked out the window again and he saw Julie Nagel outside, and then he came back and he said like he couldn't remember if he saw Higgins or if Higgins had already left, and he did remember that Higgins left, but he didn't say goodbye. And that's where we are in this sidebar.
Okay.
So are these prior inconsistent statements, or are you just reading his testimony?
Well, those are prior inconsistent statements because he said that he just testified that Higgins was there.
Okay, what are you reading now? What do you...
I can rephrase it.
Okay, don't just read the testimony, okay?
Okay.
All right, ask the question. And if it is a prior inconsistent statement, then you can impeach him. But don't just read it.
Sure. It's like when your mom is like scolding you and you're like, okay, I'm sorry. I didn't load the dishwasher. I'm sorry. And she's like, okay, but load it. I know, I'm sorry. And it's like goes on and on.
Yeah, it's like I'm literally walking over to load the dishwasher right now, and you're still telling me that I didn't. Like the dishes are in my hand. I'm ready. And that was all with Brian Albert. And now we have Caitlin Albert.
So,
and we're still on the relationship. We are very focused this day on the relationship between Caitlin Albert and Katie McLaughlin.
Kate, you would not consider Katie McLaughlin to be a friend.
She's not a close personal friend of mine.
I asked you if she was a close personal friend.
Objection.
Just let her finish her answer.
I'm sorry. Go ahead. Finish your answer.
I would not consider her one of my, again, close friends.
Okay, all right. So let's get back to my question. Would you consider her to be a friend?
Objection.
I'll allow that.
Your Honor, may we approach?
A friend. Okay.
What's the objection here? I can't wait to see. Oh, yeah.
That's Bev is also curious. What is the objection? Your Honor, as it pertains to this witness, I'm not sure what the relevance is of anything to do with her relationship with the firefighter that showed up at her house that morning. Like, this is also like the 79th time that they've talked about her relationship with Katie McLaughlin this day. And he's like, I don't understand what this has to do. Why are they asking this? Okay, what do you say, Mr. Yannetti?
Okay, what I say is that there has been testimony that she told Trooper Proctor, that Katie McLaughlin told Trooper Proctor that my client looked at Jen McKeeb and said, I hit him, I hit him, I hit him. Katie McLaughlin then testified before this jury to a brand new conversation that was back and forth involving multiple people. And she has admitted under oath that her testimony evolved. And that she also admitted it evolved after she learned that 34 Fairview was the Albert home. So this is directly on point to impeach Katie McLaughlin's characterization of their relationship as just acquaintances. We have multiple photographs putting them...
I understand. I don't see their testimony as different. Well, it's...
Right, I'm sorry, I cut the cord off.
So I think you've covered the same ground that you're covering, or maybe the end of you covering it. You're just shaking your head. So tell me, what is it that you expect to ask of her now?
Okay, so Lally, is the objection asked and answered? Because that would be the appropriate objection if that is what the problem is here. But Lally didn't say anything like that.
And also they are doing the thing where they said, like, this isn't the witness to ask, this isn't the witness to ask. Like with Katie McLaughlin, then they're saying like, oh, well, you should ask Caitlin Albert. Well, now we're here with Caitlin Albert. And she's like, well, you already covered this. Like, no, this is the person you told him to ask.
I can't. Okay, so I want to I feel like he's talking to her, so I feel like Leonetti would be speaking so slowly to be like, do you really need me to spell this out? I'm gonna. Okay, so I want to impeach her, specifically saying that she's minimizing her relationship with Katie McLaughlin, in addition to H, I, J, and K, which were the previous ones that were marked for identification, as I made the court aware. We received multiple photos after that, which were more incriminating in terms of putting the two of them together. They're arm in arm in a lot of photos. They're at a baby shower together, standing right next to each other in a small group. And this witness is with her 2 college roommates and 1 other person. And that other person is Katie McLaughlin. She is trying to distance herself, and it is crystal clear to me that she has either read social media or she has received some information about the cross-examination that Mr. Jackson did of Katie McLaughlin, where there was a big emphasis on her not being a friend. And that...
Why is that crystal clear to me? There is nothing before me that indicates that.
Your Honor, she used the exact same language, which is, I asked her if she was a friend, and she immediately jumped to, I don't consider her to be a close friend, which is exactly what Katie McLaughlin said as well.
Your Honor, it could also just be the truth.
Well, I'm entitled to explore what that truth is or what the truth isn't.
I think we're just about finished with this. I know you feel differently. You don't have to agree with me. I'll give you one more question, but I don't think you're quite...
So I don't get to introduce any of the photos, putting them together that depicts the actual relationship?
Not based on what I've seen here. What I'll do tonight is I'll go back through my notes on Katie McLaughlin. But for the same reason that she didn't get it with Katie McLaughlin, I don't see you getting it here. I'll give you 1 or 2 more questions.
Rather than take the 1 or 2 questions, I'd rather move on to another topic and then revisit it tomorrow morning.
Okay. So now, the next day, the jurors are about to enter and Caitlin Albert's testimony is about to continue. They're coming in now.
It may be appropriate to do this at sidebar anyway. Your Honor, from the defense's perspective, there was some troubling testimony yesterday from Brian Albert. You will recall at a prior sidebar, we had broken for the day at one point, and
Shouldn't Mr. Jackson discuss any problems with the witness that he cross-examined?
You'd like to hear from Mr. Jackson?
I love that. And then he's like, wait, I thought you hate him. Unless there is something regarding...
The only issue that was trouble to us needs to be addressed and can be addressed in very short order.
You can bring them in.
I think it can be addressed in very short order. During Mr. Albert's testimony, he indicated that while he was a sworn witness, that he had communications during the break with the Commonwealth. What I want to make sure of, what we want to make sure of, is we believe that is completely inappropriate. We want to make sure that does not continue to happen. It happened once. He admitted to it. I don't think there is proper protocol. Mr. Ionetti agrees with me. I just want to make sure we address it on the record and ask that the court order the Commonwealth to respect the same parameters that we respect. If there is a witness that's under oath and in the middle of cross-examination or direct examination, that witness not to be addressed or dealt with.
This is what I was saying when there was juicy stuff. Do you want to say anything, Mr. Lally? Your Honor, the only thing that I would ever discuss with a witness while they are on the stand is as far as scheduling, as far as how much time I expect them to be on the stand. I may advise as to an area on redirect, but not specific questions as far as what I'm going to ask or anything along those lines. So I didn't think there would be any problem as it pertains to this witness or anybody.
I don't want to cast aspersions, and I don't assign malintent to Mr. Lally at all. But it's the second category that's completely inappropriate. You can't talk to a witness about what you expect them to do, what you expect them to testify to, what you expect to ask them.
So I don't know whether that's right or not. It sounds right to me. But before I make an order to the Commonwealth, I need to look at the rules.
Of course.
I feel like I know those rules.
We all know those rules. That is like 101. You can't talk to a witness while they're on the stand, except about scheduling. And Lally knows that good and well, which is why he went on about scheduling and then slipped in at the last minute. Oh, yeah. And also, I told them what I'm about to ask them about.
Yeah. Like, I know that's not allowed. What rule? Bev's checking like her rule book. Okay. So anyway, so now Caitlin Albert's back.
While you were in Maine, there were 7 of you in a hot tub together, correct?
Objection.
Sustained.
You were in a hot tub with Katie McLaughlin in Maine, correct?
Objection.
Also, there's one part where he's like, you were in bikinis with Katie McLaughlin. Like, okay, let's relax. Okay.
Okay, Mr. Yannetti. I don't understand why I'm not allowed to fully explore the relationship between Katie McLaughlin and Caitlin Albert.
Because you already got what's relevant. You don't have to understand more than that, Mr. Yannetti. I sustain the objection.
Your Honor, to understand the court's ruling, you are now prohibiting me from asking about any other specific instances where they've been together over the last 10 years. And the extent of their relationship, because that's what I'm being prohibited from doing right now. I am being prohibited from exploring just how close they were, which is a really good laying record for appeal, is what he is doing quite well.
Everything I've been saying from day one, the Yannetti is my favorite, and all these sidebars really just prove like he does everything with such just like finesse. Like even when he's being a thorn in her side, he does it with just such like class. And then he still gets this. I'll sustain that objection. So you can ask questions and I'll sustain or I'll overrule the objections.
That's how trial works.
So basically you can go back and keep doing trial. So now they do that.
Who are your college roommates?
I'm sorry, I didn't hear the question.
Who were your college roommates?
Oh, yeah, sustained.
How many college roommates did you have?
Objection.
Sustained.
Fair to say that Katie McLaughlin has been with you and your college roommates.
Yes.
When was that?
2015, 2016.
And there were 2 college roommates that you and Katie McLaughlin were with, correct?
I had multiple college roommates at that time, and 2 of them were the mutual friend that Katie and I share.
And in fact, there was an occasion where you were in a kitchen with your 2 college roommates and 1 other person, correct?
Check.
They're not going to let you get anything.
Why is that not admissible?
I'm not here to answer your questions, Mr. Yannetti.
Your Honor, I would ask the court to put on the record why this is being disallowed in light of the case law that supports a constitutional right to explore the bias of a witness. I believe I'm entitled to that.
So you can explore bias. This is cumulative. She's already testified to it.
She has not testified.
She just said she was with her 2 college roommates. Like,
Why
yeah, but
am
not
I-
Katie McLaughlin.
Right. And why am I not allowed to explore that Katie McLaughlin is the only one with her and her 2 college roommates? Why can't I answer that question? I haven't even offered the photos yet.
Do you have an objection to her showing this photograph? I do. I don't see how any of this is relevant, and I don't understand how bias of this witness has anything to do with her relationship with Katie McLaughlin.
I'm not exploring the bias of this witness. I'm exploring the bias of Katie McLaughlin. The case law is clear that it rises to a constitutional level under Article 12 and the Sixth Amendment. Case law is clear that not only all the defense needs to do is demonstrate the possibility of bias, and then extrinsic evidence is admissible. There is case law directly on point. I can get the case for you at counsel table. Right now, I'm trying to explore extrinsic evidence, and I'm being denied this by the court. That's why I'm pushing so hard. Katie McLaughlin changed her testimony. She admitted she changed her testimony. She admitted she changed it after finding out the Alberts live in that home. This witness has already contradicted her testimony in multiple ways, and I am trying to explore the nature of their relationship that she minimized. It's also very concerning to me that when asked who Katie McLaughlin was, she used the identical language that Katie McLaughlin used. Nobody asked her, not Mr. Jackson, not me, whether they were close friends. As they both said, we're not close friends. Your Honor, I don't have a lot more on this topic, but I will be offering these photos. And at a minimum, I should be able to demonstrate that it's not the large group solely, because that's what she's saying. Every time I ask her if she's friends with Katie, she talks about the mutual friends.
Show her that photo, question that photo, and then move on. And they did. This comment is so true. Stephanie B said, these sidebars show just how hard these lawyers worked and how badly their hands were tied by the court. And that it's like infuriating listening to.
Yeah, it's why we needed them. We need to see, like, is this real? Is it what we think is going on? What was actually going on? And as far as we've seen, that's been completely borne out.
Exactly.
I'm a little blown away. Oh, go ahead.
No, go ahead.
I was just going to say I'm a little blown away at how much Bev says you're asking the wrong witness that, and then and then when that witness comes up, it's, oh, you already dealt with that. We're like, well, we argued about it at sidebar that we didn't get to elicit it from either witness, and now we get no one. And her answer is, oh, we'll bring them back on rebuttal, which is an insane thing that, like, I just don't want more rebuttal.
It feels like they needed to have like a cork board with like Post-it notes on it that said like, I owe you testimony from Caitlin Albert when she comes because I did not get it. And then you have to be like, here, remember, you wrote me this IOU testimony. So now I'm going to cash in on that.
Yes, much like the transcript is supposed to do.
Exactly. With their hands being tied and like this showing us so much, it's also like, I keep reminding myself, like, this is just the very beginning. Like, they're just realizing now how much they're going to have to fight. And I just can't wait to see how that evolves throughout this trial. And then in the retrial, like how the approach changes or like how the fight changes.
Right, because we kind of started with one of the last days, and that was when Jackson had sort of like a revelation, like, Your Honor, basically we're at the point where we cannot do our jobs at all. And that was day 19.
The sky blue.
Yeah, no.
So now we're at Sarah Levinson and hearing about Julie Nagel's black blob on the yard.
And as you're driving past the house, what, if anything, does Julie say?
Objection.
Ask it differently, Mr. Rowley.
As you're driving past the house, what, if any, conversation were you having with them?
Objection.
So I'm going to see counsel at sidebar on this one issue.
Like, also, why do the witnesses always look so mad when they get asked something and then there's an objection? Like, Sarah, what are you mad about? You're supposed to just be like a random witness who's just explaining what happened. Like, why do you look so downtrodden?
They feel like they're getting in trouble even though they're not.
Right. So why don't you just tell us for the record the objection, Mr. Lally? Hearsay. Okay. When you object, make sure you stand up. I'm sorry. So go ahead. So it is hearsay. Wait, this part also confused me. Because wasn't Lally the one?
Yes.
What just happened? I
I'm
feel like this
confused.
is wrong. Yeah, I don't think that was supposed to be Lally. Hold on. Can we go back to that? I think that's Yannetti
And,
talking. I think it's
as
labeled
you're
wrong.
driving past the house, what, if anything, does Julie say?
Objection.
Yeah. Okay. So that's mislabeled. Typo.
Okay. Hearsay.
Because also I was thinking like why? Because she wouldn't tell Lally to stand up. She would have told whoever just objected, Yannetti. Anyways.
Right.
So it is hearsay, but I think it's an exception because I'm not offering it for the truth of the matter asserted. This is his favorite argument. I'm offering it for the effect on the listener, essentially. What I anticipate the response to be is Miss Nagel indicated something that she saw on the front lawn area and then drew Miss Levinson's attention. Now Miss Levinson didn't see anything because by the time she looks over, they already passed the lawn. But I think the fact that the statement was made and her attention was drawn to it is relevant. What do you have to say about that, Mr. Yannetti?
So can I just say that the state of mind objection, which is what the effect on the listener objection is, that's a hearsay exception. But that means that whatever the effect is of the Julie Nagel statement is on Sarah Levinson also has to be like relevant. Like because that Sarah Levinson sat in the back and heard Julie Nagel say something and was like, okay, and like didn't do anything in reaction to that, or whatever she did has no impact whatsoever. Then it's not relevant. Then you don't get to bring it in. It's obviously just a way to try to sneak in what Miss Nagel said without actually having to essentially bolstering what Julie Nagel is going to say. It's like it's totally inappropriate. We all know that it's inappropriate, and Lally can't even articulate an argument as to why what Sarah Levinson thought is relevant. Anyways, it bothers me when it's so straightforward and the attorneys obviously know what's happening and they make these arguments anyway. It drives me nuts. But I can get it together. Okay, Yannetti. The stated offer of proof is that it is offered for this witness's state of mind, which is not an issue at this trial in terms of what she thought or didn't think. Oh, yeah, thank you. It's what she saw or didn't see. So I still maintain that it's hearsay.
Yes, the statement itself is not going to come in. It's not an excited utterance or anything, right?
No, and also Lally didn't raise the excited utterance, which is another hearsay objection, but thank you for spoon feeding him another exception.
So it won't come in through this witness, but you can certainly talk about the event, just not the statement.
Okay, that's fine. Thank you.
I feel like these are all mislabeled too, because shouldn't that be Lally saying like, okay?
Yeah,
right?
Yes.
The court reporter got lazy right here or something, because also they wrote law instead of lawn. Right here, the front law.
I will never blame a court reporter for anything that they've ever typed in the history of time. I'm gonna leave it at that.
I will follow your lead on that then. They were probably just tired because they were listening to Lally for so long.
Yes.
About 9 months after January 29th of 2022, you will agree with me, was Michael Park, correct?
That's correct.
And almost a year after that, you were visited by 2 female members of the defense team, were you not?
Objection.
Oh,
My home was.
okay. Do you recognize Ms. Little seated at council table as being one of those 2 females?
Okay, I'm going to see it type.
Okay.
I didn't hear an objection from Lally, but we're going to sidebar anyway.
She just wanted to see them. Someone said they live for the commercial break, so maybe let's take a 1-minute commercial break, and so that I don't get so exhausted again. So here we go. Here's commercial break. Okay, let's do I do not remember. Well, it would just give me anxiety to look out the window. It could have been early. I don't know time. Well, I think in the text I say, "Ya hot." The taillight in this case was shattered when it was in struck John O'Keefe's arm. I do not know. Bukkake. It just, because it just did. Do not recall. That's just evidence at the scene. I didn't put the evidence there. Don't remember. The unprofessional and regrettable comments are something I'm not proud of. My aunt, JJ? It was an incorrect transcription of time, sir. No, it didn't upset me at all. It was just a flirtatious text. That's it. Then I go up 3 flights of stairs. It was just, well, I think you know what I mean. And I remember it being icy out, and it was kind of a steep driveway, and I was walking up the driveway, and I slipped down the driveway, and I tried to catch myself, but I had something in my left hand, so I tried to brace myself with my right hand, and then I ended up sliding down the driveway. Okay, so this is Randy, right, doctor? Did you give any consideration to whether a hat would come off Randy? Now, since Randy's on a harness, he's not going to be thrown the same way as would happen in real life. Are you talking about frozen grass or paved? Talking about Randy right now. You keep referring to Randy as a crash test dummy. He's no dummy, right? I don't want to misrepresent Randy. Did you keep Randy's original arm? And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you? We'll talk about Randy later. Just a reminder that I cannot wait for the next retrial sidebars, but I guess we're gonna have to wait like a long time. Corri said something like 6 weeks between each drop. So we're looking at a long time. Hello again. Oh, it's dark there now too. Yay. Welcome to the darkness.
Pitch black.
So you don't have that much more light than us.
No.
I'll just hate daylight savings time for all of us then. Okay. Back to the most exciting person on earth.
About 9 months after January 29th of 2022, you will agree with me, was Michael Clark, correct?
That's correct.
And almost a year after that, you were visited by 2 female members of the defense team, were you not?
Objection.
My home was.
Do you recognize Ms. Little seated at council table as being one of those 2 females?
Okay, I'm going to see it.
When it go, oh my gosh, you guys, now it won't go to the next one again. Oh my goodness, we might have to do a whole nother commercial. Hold on. Wait. Okay, never mind. Share this tab instead. Slideshow, presenter view, da-da-da. Okay. If there was an objection, so there wasn't an objection. If there was an objection, I have no idea where you're going with this.
Okay.
What's this?
So Miss Little and a female investigator went to the Levinson home attempting to interview Sarah, and she refused to speak to them.
I think you can leave Miss Little out of it.
Okay.
I don't like the lawyers to inject themselves for.
Okay.
You can just ask her that.
Okay.
Okay. Now we're on to Julie Nagel, and she is using, there was like a very okay, first of all, there's a very sketchy, I should have put this clip in, but there's a very sketchy thing that Adam Lally does where he uses pictures of 34 Fairview like covered in snow to then ask witnesses to talk about that night. And I feel like it's meant to like make the jury envision that there was that much snow that night. So he has this picture in the daylight where 34 Fairview is covered in like 20 inches of snow. And he's asking Julie Nagel to use the laser pointer. And the vantage point is different too. So it's like looking across the street at the house. And he's asking her to use the laser pointer to indicate where she saw Karen's car. That's where we're at for this.
Okay. This testimony is coming in. I fully realize that. However, my objection is the lack of foundation here because I believe the testimony that she saw the vehicle move from one point to the next while she was inside the home. Now, Mr. Lally is questioning her about where Mr. Nagel's car was when she came outside. And we've morphed into where my client's car was when she was inside. So I just want a clarification for the jury that what he's asking right now is what she saw when she was inside the home.
Okay, you can do that on cross. I think it's really clear. I think there was not another car there when she left that drove up. Now we're here. I did not get an opportunity to address your point. Now that we're here, I did not get an opportunity to address your point about Mr. Lally speaking to a witness who is on the stand. So now we're back to the thing that they brought up at the very beginning of the day when she had to check the rules. I didn't get a chance to look it up, but you can't do that. I'm not allowing you to do that. Sure. All right. So if I'm wrong, you let me know, but I think that's improper, Mr. Lally. So I'm not going to let you do it. Okay. So she's basically saying, I told you I was going to go check the rules. I didn't check the rules, but I decided that I'm not going to let you do it. So, and I'm going to tell you right now, because I am letting you do something else right now that you shouldn't be doing, but I want to kind of look like I'm also being hard on you.
Yes, that is exactly what is happening in my opinion.
Now, there was this really funny moment where the jury gets dismissed for the day, and then Julie's like, can I leave? And then she's just like kind of left there and nobody answers her. And so jury exits. Julie is confused if she can leave. So, Your Honor, I just wanted to remind the court and counsel. So tomorrow, Miss Kuhn from the UC Davis lab is flying in today. I anticipate I need her to testify tomorrow because she's flying out tomorrow. Okay. Was she otherwise a rebuttal witness or was she a case in chief witness? Well, until Mr. Yannetti. So weeks ago, Mr. Yannetti stated in open court that the dog thing wasn't something they were pursuing. But then when he mentioned her in his opening, she became a witness in the case in chief. Okay, all right. So you don't have much longer with this witness? No.
Can I ask, Your Honor, it was a bit confusing, but I thought at one point this witness had said that she told Mr. Lally this information about the length of the object prior to her testimony today. Did I misunderstand that?
I didn't hear that. I heard that Lally asked her and she answered today.
Okay.
I thought she agreed with you that there was... She and I never talked about that.
That's all I wanted.
It's frankly a question that came to me at the end. Okay.
Fair enough. Thank you.
All right. We'll see you tomorrow. The next morning. Good morning, Your Honor. Good morning.
Good morning, Judge.
You have to stop being late, really.
I just wanted to very briefly put on the record.
Why don't you step aside?
Oh, of course, yes. Jackson, I just wanted to put very briefly on the record with regards to Miss Kuhn. We want to interpose an objection just for the record in terms of her testifying before the foundation has been properly laid. I sort of expected it. I knew she was going to be taken out of order. Mr. Lally let us know that, but I expected.
Because of personal reason, blah, blah, blah. Is that what it is? Yes.
And I have no problem with that whatsoever. I just want to make sure that I didn't waive any objection if the later foundation for her testimony is not established. I think it will be.
If it's not established, move to strike it.
Okay, that's what I wanted to make sure of. That's all. Thank you.
Okay. And then Laura McLaughlin does her little brown nosing again. And she's like, based on the court's order yesterday, the Commonwealth did review the professional rules of code of conduct. Okay. The Commonwealth did not find any rule that pertained to the situation or the issue that the defense counsel raised. The closest thing would have been the professional rule of conduct 3.4a, discussing an attorney's duty to not obstruct evidence. That's not what the Commonwealth did nor intended to do. And there's no cases citing the rule for any proposition or supposed issue raised by the defense. However, given the court's broad discretion, the Commonwealth, myself, and ADA Lally will abide by the court's order as it likely falls within the judge's broad discretion pursuant to Criminal Procedure Rule 21 and sequestration. So, myself and ADA Lally will abide by the court order as I presume defense counsel will as well. Okay, unlike all of you, I have never been a prosecutor. All right. Are you still moving forward for that, Mr.?
Yes, Your Honor, we are. Anybody from the Commonwealth's team, their investigators, their victim advocates, the trial team themselves, nobody from the Commonwealth, just like nobody from the defense, their victim advocates, the trial team themselves, nobody from, did I just read this? just like nobody from the defense should be engaging a witness who is currently under oath during the breaks, overnight and things of that nature. It's just not done.
I think investigators is a little too broad. Police not allowed to talk to witnesses?
Not while they're on the stand, not while they are under oath.
What do you say? There's no rule that suggests that. If that's the court's order, the Commonwealth would abide by it. However, I feel as if victim witness advocates need to be able to speak to the witnesses. As it came up in this case, our witness was confronted about a conversation they had with a member of the Commonwealth, and their answer was they asked me if I wanted any water. So I think to effectively, move the trial forward, advocates or witness people need to be able to ask people, do they know where the bathroom is? And you're going to be up next in 5 minutes. Just normal ability to facilitate the time management of the trial.
To be clear, that's not what I'm objecting to. I'm objecting to any interviews or discussion of the substance of their testimony. Asking where the bathroom is, what time do you need to be here, can I have some water? I have no problem with that.
How long your testimony is going to be?
Correct. I mean, you're going to be another hour. I have no problem with that. I just don't think it's appropriate to talk to them about, I'm going to ask you these questions. I expect that Mr. Jackson will.
Yes, I don't think that's proper either. I may be wrong, but I do know sometimes things come up during trial that a police officer has to go out and find a witness or approach a witness or something based on something that's been said. So I don't want to tie the strings of law enforcement. I was concerned you raised it regarding the lawyer, Mr. Lally, and that's what I addressed.
Right.
So, Mr. Lally, you're not to flag the witnesses that you're going to examine them on or do redirect on or any other substance of what you're going to do. Understood, Your Honor. Just so the record is clear, that's not what happened in this particular case, even though that is what you literally said that's what happened. I went to tell the witness, this one being Mr. Albert, how much I anticipated he would be left on the stand. He asked me a question as far as, are you going to cover this in your direct? And I said yes. There was no substantive conversation about I'm going to ask you this or Mr. Jackson may ask you that or anything along those lines. But whatever the court's ruling is, obviously the Commonwealth will abide by whatever the court tells us to do. My understanding has always been when a witness is on the stand, you can't discuss anything of substance with that witness. I understand. And that's what I always thought, and that's what I believe. We will leave it at that. Thank you.
Thank you. See, this is what is so frustrating is that they all know that this is a rule. And because Law McGlaw has
I'm not a lawyer and I know that.
Exactly. And I'm like, guys, wait, can you hear me? So
yeah.
Okay. Because she suggested that there's no rule of professional conduct. Maybe it's not in those rules. Maybe it's in the Superior Court rules. I'm obviously going to have to go find it now, but we all know what the rule is. And asking for water or bathroom breaks that's not the problem here. It's the substance. And he's like, well, all I did was say, like, this is what I'm going to ask you next or whatever. I'm like, yes, that's the thing you can't do is talk about the substance just while they're on the stand. Like, not, the rest of trial, just in those few moments. And it's probably going to be half an hour maybe. Just give me it's so ridiculous.
Yeah. Well, and you just made such a good point because I feel like what Laura McLaughlin probably did is looked up in like a different book. Like, it's like, oh, it's not in this rule book. Like, it would be like a referee being like, oh, well, it's not in like the team handbook. And it's like, right, it's in like the rules of the game handbook. Like, she just looked in something that obviously wouldn't have it. And she's like, well, I looked it up in here and it's not there. This sidebar just made me laugh because this is just more proof that for some reason, as much as Bev couldn't stand Alan Jackson, she like really can't stand Liza Little.
Which is unfortunate because she's like the most helpful person on the defense team, the one she should like the most.
Yes. Time for the Tory Burch.
Just very briefly, if you don't mind, maybe I should keep my glasses on to make it clear that I'm from California. I didn't want to run out of the courtroom.
No, you can't run out of the courtroom at any time.
Okay.
But did you want to take this morning recess, or is this something that might take more than a few minutes?
No, it will just take a minute as long as I'm allowed to leave you guys.
Okay.
Thank you.
That was it.
Okay, got it.
Like, I feel like Eliza like had to pee and she's like standing there still being like, okay, I'm like literally about to pee in my pants. Can you guys just let me go?
Yeah, she's like, I've been yelled at for everything else, like not standing at the right time, holding up a poster board at the wrong time. So I was asking if I was allowed to exhale, and you're now looking at me like I'm crazy.
Yeah. Okay, we're at Ricky D'Antano.
And then it was only after you talked to someone else, again, not the prosecution or the defense.
Objection, Your Honor.
Quick one. What is the objection? Oh yeah, we're going to get into some good stuff now. Okay. I mean, I think Mr. Yannetti has danced around it, but at this point, I don't know. I think the point has been made. So, also just here, because that was so quick. I wanted to play that one again. And this is on the heels. I know this was on the heels of Ryan Nagel earlier that day or the day before or something, maybe right before this, saying like, oh yeah, when I talked to the feds. So he like just spilled the beans. So this.
And then it was only after you talked to someone else, again, not the prosecution or the defense.
Objection, Your Honor.
So this is on the heels of that. So Lally says, I mean, I think Mr. Yannetti has danced around it, but at this point, I don't know. I think the point has been made. So asking any more questions about this particular topic, I think is going to end up eliciting a response similar to Mr. Nagel's. We're just going to get into an area that's prohibited. Can you say proceeding? I'm just concerned that...
I know.
Just so the record is clear, I do not say for a second that Mr. Jackson intended to have that result. No, I didn't mean that otherwise. I know you didn't. I just wanted to.
No, I appreciate that, Your Honor. So I think we are past. I'm not talking about the feds, not now, because now I'm asking about the state police. An interim proceeding. It was actually not testimony. It was an interview.
Right.
So I'm trying to.
It was testimony. He testified at the federal grand jury. I didn't think you were going after this testimony. I thought you.
That's right.
So I didn't understand what you're doing. I thought you were talking about a report.
I was. It was a report. All I'm after right now is that he talked to the state police in September. So I'm not asking him about anything to do with any other agency. Just playing off of the first time they talked to him was in September. So I don't think there's a danger of or anything else at this point. I'm leading him, and I'm going to say it was the state police in September. I think he will agree with that.
Okay, I would just ask you for caution. I didn't understand where you were going. I thought it was a report, but I know he testified at the federal grand jury.
Right.
And if you're asking a report and he's talking about the federal grand jury.
Of course. I mean, it's Yannetti is doing everything correctly. He's keeping it extremely tight. He's obviously trying to avoid the thing that the court has clearly said, do not dare mention this. He's doing it all right. And it's like between Lally and the court, they call him over to scold him for doing it right. I don't know.
And it's like every time that Bev's not entirely sure where they're going with something, she's like, well, are you about to just ask, were you interviewed by the FBI? And it's like, no, even when you're not entirely sure, Bev, I promise you, Yannetti's still following the rules and doing the right thing.
Yes. Where was his concern when they were allegedly dancing close to the harassment discussion and opening that door? There's no concern about dancing closer there.
No, Bev was like, let's turn the music up.
Mm-hmm. Speaking of.
So now we're on Allie McCabe, and she's having a hard time.
And do you recognize that, man?
Yes.
And what do you recognize that?
This is from my phone, my text messages.
And the second page, what is that?
Colin's contact information.
Are those screenshots that you took from your phone and provided to the troopers in August of 2023?
Mm-hmm. Yes.
Mayor, Coach General.
Yes.
I'm also seeking to introduce it as
Objection.
So they want to introduce the screenshots, and Yannetti's been waiting for this moment. He's like, he was ready to object. He was like on his tippy toes.
Your Honor, I'm objecting on multiple grounds. One is that this is rank hearsay. It's being offered for the truth of the matter asserted. Secondly, and equally important, is that these screenshots are unreliable. We don't know that they are what they purport to be. In other words, there are times listed there, but again, being offered for the truth of the matter asserted, which by an iPhone can be changed very easily by going into settings.
And just a side note, why was he so obsessed with the fact that you could change your settings and then change the times, but never mentions that you could just doctor a screenshot? Like you could just go into Canva and just make a fake screenshot, or you can use Photoshop and just make it look however you want. Like he was so obsessed with this idea about changing the settings and like nothing about the fact that the fonts don't match. Anyways, keep going.
Because it's possible that the screenshots were taken in front of a police officer or someone who could corroborate it, and so they authenticated.
Wouldn't we have heard that then? Like, wouldn't they have said that?
Yeah, I don't remember this testimony as well, but yes, I mean, who knows? So many things. Okay, so we don't have a forensic extraction of the phone. The police did not. Okay, here we go. The police did not actually ask to take her phone and confirm that those times are actually accurate. They chose not to do that. And given that her phone is gone now, they robbed us of any ability to challenge those times through forensic methods. So I believe that these are inadmissible in the form that they are in. If the court is inclined to overrule my objection, I would ask for a voir dire to be done before these are admitted.
Okay. What do you say, Mr. Lally? Your Honor, what I say is that the witness on the stand is a participant in these conversations and can authenticate those conversations under Purdy. Secondly, I would say as far as any questions that counsel has to them goes to the weight and not the admissibility. How long of a voir dire do you need? She's like literally like, I didn't want to say yes, but Lally, you just didn't give me anything.
Yes. 10, 15 minutes.
All right. I'll give you a short voir dire. Your Honor, if I may, just for the sake of not coming back up, I also intend to introduce those two. They are screenshots that she took for photographs of Colin Albert from February 11th. Essentially, what these are is two separate photographs from the defense that show the Albert's home. She was present during this event. What does that mean? Photographs from the defense. She was present during the event, so she can authenticate that's what Colin Albert looked like on February. Who is the one? That's Nicole Albert. All right, so we'll have a voir dire on it. Jurors, I'm going to ask you to step out for a few minutes. Where is this still the same thing? Yeah, okay. Madam Court Reporter, would you please mark that for identification?
Your Honor, maybe I'd be excused for just 1 second to pick something up in the hallway.
Okay. And then they mark some things for identification, blah, blah, blah. Okay, and then this is after the voir dire.
Your Honor, the only thing that I was going to bring up, I understand the court's ruling. We object to it, but I accept it, obviously. But with regard to the photos, Your Honor, there's no need to have that date underneath the photo itself.
I didn't even notice that it was on there.
I'm just asking that that be cropped off. If he wants the photo in, she can testify to the date. That's hearsay. That should not be a part of the photo.
Do you care? I don't care. But again, I mean, she was there for it and can testify to the date that the photo was taken.
Oh, that's what I just said. As long as it's not on the exhibit itself.
And at some point in time, you realized that you'd have to be a witness in this case and have the unfortunate incident of having to talk to me, right?
It is so cute. Wait, we need to hear that one more time. That's just like, Nettie, you're so cute.
And at some point in time, you realized that you'd have to be a witness in this case and have the unfortunate incident of having to talk to me, right?
She laughs.
Cute.
I know, so endearing.
Okay, then there's an objection. I just want to let you know, the other day when Brian Albert Jr. testified, he said he couldn't differentiate between the two hearings. One was for the harassment he and his family have received. I think you're opening the door if you get another answer like that, and the Commonwealth can run with it. So focusing on the screenshot, maybe this was supposed to be before that. So focusing on the screenshot, it may be why she didn't do it before, why she felt the need to keep these things.
I see where the court is going, okay?
I'm just warning you on that.
I understand. I understand.
Thank you, Your Honor. I think the door is already open. I think it is too, okay? So, yeah. So the door opened on harassment. I forget exactly why. I think there was supposed to be a clip in there.
So they can't describe the hearing they can't describe the federal grand jury hearing or any other prior proceeding to differentiate it from the state proceeding. So therefore the witnesses also can't differentiate among multiple state proceedings. So their hands are tied regarding the Fed's information, which has the a direct ripple effect of allowing witnesses to essentially open the door to harassment, because there are other proceedings outside of this trial that relate to the case, but not directly. It's like insane. They are damned if you do, damned if you don't, in such an unbelievably unfair way. I can't believe this is happening and that they are keeping their cool this whole time. I mean, I understand you're in the zone when you're at trial. You can keep it together because you're sort of performing and you're on guard. But right now, I'm like internally raging for them. Externally.
Well, and it's like you kind of have a plan going in where you're like, you've been a lawyer for long enough. I assume you're kind of like, okay, this one might be a stretch, but we're trying to get it in or something, blah, blah, blah. And then this one, like, is going to be a shoe-in, or this is going to be an obvious whatever. And it's like any of those moments that I feel like the defense thought like, okay, clearly this won't be allowed, or clearly this will be allowed. They on the fly had to be like, oh, it's not in this case. Okay. That was everything that I had pulled. I just want to make sure we didn't miss anything, because then we're literally done.
Wow, we've really crushed it.
I know.
And I have no idea. Thank you so much for putting together the slides and everything. That makes it so much easier than like you having to scroll actively while we're rambling.
I feel like it was so much, it like set the scene better. Like it made it feel like, okay, I like remember where we were. And it was very satisfying to get like to see it in context, and then to hear that like Karen's team was saying to Bev the things that we like wanted to hear.
Yes, exactly. The Ryan Nagel one is the one that sticks out, because I remember when he said the feds and everyone like freaked out and watching it. They're like, oh my God, the door is open. Are they going to get in trouble for, bringing out the feds? And then they immediately have a conversation and she's like, okay, you can't ask Ricky D'Antano any questions anymore because he might say the feds too. I'm like, no, that's not the reaction. That's not how this works.
Yeah. Also, like, why it like, was that a weird decision in general? Because it felt like, I forget exactly what it was, but in the Adelson trial, it felt like there were other things, other like proceedings that happened and stuff, and they were just open about it. They were like, did you say this in this court proceeding? Like, did you say this to this person? And nothing was like hidden and secret, and they didn't have to like sidestep anything. Like, is that a normal thing that they're like, in the retrial, you can't talk about the first trial, and you can't talk about talking to the feds? Is that normal?
Definitely, you don't want to talk about the first trial during the retrial. However, so many witnesses did, and Alessi, I recall one day when he just started like going into it, and she was like, "Hold on, guys," that kind of thing, and it was like that sort of. The cat was out of the bag to such an extreme degree that I think they kind of gave up on it, but normally you wouldn't. But in a prior proceeding in the same case, not like prior trial, but whatever, that's not
like
as big
a
of a deal.
state grand jury or whatever. Yeah.
Yeah, exactly. But the feds piece is what makes all of this insane. It's insane on a million different levels. And when people say one of one, like there is nothing like this case. And that is a significant part of it, and why all these crazy rules and everyone asking, is this normal? No, it's not normal. No, they shouldn't have to dance around the feds thing and then have harassment evidence, either have to not go into an entire area of inquiry or essentially give in to opening the door on something incredibly prejudicial for Karen Reed on the harassment piece. It's just absurd.
Yeah. That makes me feel better, honestly, to like hear that from you and to see it in the sidebars. It's like, okay, this was as like absolutely, like you said, one of one that it felt like in the moment.
Yes, definitely.
Thank God, at least in the end, it turned out okay.
I know. I was worried the whole time. The whole second trial, I was bugging out because I'm more of like a, prepare for the worst, hope for the best type of thing. And so I was just like, oh my God, like this is going to be. She is going to keep out something critical. The Mike Easter stuff, I was very worried about because that's key to the Bowden, and it all worked out. He had phenomenal lawyers. Everything was fine. The jury totally got it, but I was never comfortable. Like a lot of people are like, oh, she'll be fine. There's no way. And I'm like, there is a way. There is a way. It's just, it would be wrong.
When I rewatch anything from the first trial, it is bananas to me that she wasn't just like They didn't walk into the room and say like, okay, so she's not guilty, right? Okay, let's all go home now. Like, there's so much shady stuff that was happening that it's like, I think that's why we were all scarred.
I was very upset by the defense closing after the first trial. I couldn't believe the way it was the way it was delivered. I'm like, where's the picture of the verdict slip with the X's over it and showing them how to get to the result? It was a lot of, you know, flowery language that the jury is not going to be considering or care about. And it was obviously corrected in the second trial to be one of the most like phenomenal closings you could ever imagine.
I mean, I feel like Alan Jackson was giving that first closing to a jury that he felt was on his team. Like, it was a very like, this is your moment to like make history and go out there and do the right thing. And it wasn't like, I think in his mind, he had all of them and he was like rallying the troops instead of realizing like, oh, some of those troops might not be fighting your battle.
Yeah, he needed to do more cite exhibit numbers. Cite 209, Michael Proctor's texts. Go back and read them.
Or just what he did in the second when he said like, let me tell you what reasonable doubt is. This is reasonable doubt. This is reasonable doubt. This, and you only needed one of those and you have 112.
Yes, exactly. I personally love listening to Georgia Kaufman's closing from the Charlie Adelson trial. I'm obsessed with it, both the primary close and the rebuttal. It's phenomenal the way she goes through the evidence, tells it in a story with a great personality. It doesn't go over the top, but she cites, you know, a few specific exhibits that are critical to the case. It's so good. I love it. And I was hoping
I need to watch that.
Georgia. Yes, totally. I'll send it to you.
Writing myself a note. Yay. Well, I hope that we can do this in the next drop. We will hopefully give the people what they want.
Yes, hopefully. Hopefully, I hope to get an estimate on the timing soon, but I have no idea. I mean, we just haven't discussed, you know, when the next drop is going to happen. But I personally think a month to 6 weeks, given the holiday, is reasonable.
Okay. So you guys don't get like too impatient till like February 1st. We can start being like a little bit annoying because we're getting inverted video sidebars.
I cannot wait. Well, thank you so much for having me as usual. I really appreciate it.
Thank you for doing this.
So fun for me.
Have a great night. You're amazing. We're obsessed with you.
Back at you.
Happy New Year.
Happy New Year. Bye.
You guys, how fun was that? I loved every second of that. That was amazing. I need to say thank you to some people. Mama, she said, yay, finally catching alive. Welcome. Yay. Gigi has got your back. You were just so incredibly generous and gifting memberships, and yay to everybody who got those gifted memberships. And you became a member. This is so exciting. Jen Fox, I literally might need my maybe I'll do a members only all about how much I hate daylight savings time, because I have a lot of thoughts about this because I hate it. I hate changing the clocks. I hate the darkness. Thank you, Carol Pack, for becoming a member. And Romy and Mass said, you two are the best. You're the best. You guys are the best. Literally obsessed with all of you. Carol, thank you for your $5 super sticker. Do I sound like a real YouTuber yet when I say these? Because I don't feel like one yet. Okay, it's standard time. I know I always mess that up. Thank you. M11-1969, daylight savings ended in November, and it's standard time. You don't like, I know it. I have to remember that. I just hate the concept of that there are two different times. Another reason why I hate it. I can't even get it right which one we're on. Love these reads. You're doing a great job, both of you. Thank you so much. I really appreciate that. Gigi has got your back said, I assure you, this is exactly why I'm not an attorney. Yes, same. I would go over the bench and somehow see eye to eye with this judge. That's hilarious because I feel the same way. And I would be like, I would also probably start crying because like when I feel too many things. I would probably just lose my mind. Oh my gosh, you gifted 10 more memberships. You're so kind. That is literally the nicest thing. An American Dreamer said, Happy New Year, Emily and chat. God bless. Thank you so much. You guys, it's going to be 2026. Like, how is that possible? I want to plug Trial Channel again, that if you can't get enough of these sidebars, you can now go hop over to Trial Channel. Oh, I could set the thing. I need to learn how to do that, but I should set the thing to go over. That's too stressful to do right now. But go over to Trial Channel now and listen to the sidebars in like context of how they were in the trial. Also, I saw somebody was asking me to redo the first ones that we did without video and do them with video. You can get that at Trial Channel now. So you don't need me anymore. You're all done with me. And Mama, she sent a super sticker. That was so nice of you. You guys are the best. This was so much fun. Hi, KY Heather. This was so fun for me. Now, what am I going to do with myself until the next, how do I make that a link? I don't know how to make that into something that that's actually useful. Yeah, but this was so fun, and I'm going to go pack. We're doing a little staycation in Boston for New Year's Eve, so I'm going to go pack for that. And I hope everybody has a very happy new year, and I will see you in January, the most fun month. I will see you in 2026, if not before. You're all amazing. I'm literally obsessed with all of you and the fact that I get to do this, and that like I got to do that with Corri, and I'm just very, very grateful. And I hope that all of these blessings continue in 2026. Have a great night, everybody.
John Keefe was 46 years old. Psst, Peg, time to cry, because remember, oopsies, you thought he was 45. John Keefe was not a buffalo on the prairie. When I was a kid, I used to throw boulders off of bridges. Ah, what a thrill. The dater is the dater. And tonight, I'm going on a dater with Shannon Welcher. We have no idea how the collision happened, but if you have any doubts left, remember this. My best friend, Jen McCabe, said Bella's mom. Of course Karen hit him. Speaking of Jen McCabe, she's a soccer mom. She doesn't use Signal like Arca. She keeps everything right out in the open, like how long until John dies in the cold. Didn't need Michael Proctor. Tully is our Uber driver now. As the trial ends, we remember Barrows lied not, Kelly Dever. I know our times changed to whatever, but cops can't solve crime in bad weather.